much you want to rely on Wong Kim Ark.
But there is a statement in there that says, so long as they are permitted to keep in mind
rocking with Uncle D. You're now rocking with Uncle D. Blizzard King. You're now rocking with Uncle D. Blizzard King. You're now rocking with Uncle D. Hit subscribe.
Subscribe to my guy, Uncle D. Tell him Big Bad sent you.
Spurling. I'm an attorney here in Houston, Texas, an advocate for black men, largely because I am a black man. I'm a black father, I have black sons. Hey man, I do what I do.
It's the parents you have us focus on. And, what if, is it the husband? Is it the wife? What if they're unmarried? Who's domicile?
Well, in the executive order, it draws a distinction between the mother and the father. It's really the mother's domicile. I think that would matter.
Well, but 1868 matters, you're telling us. So what's the answer?
The 1868 sources talk about parental. I'm not aware of them drawing a distinction between mother or father, but they say the domicile of the child follows the domicile of the parents.
And how are we going to determine domicile? I mean, would we use contemporary sources on what qualifies as domicile in a state, or do we look in 1868? And do we have to do this for every single person?
And again, I don't see a strong distinction between those because, of course, domicile is a high-level concept, has been pretty consistent over centuries, which is lawful presence with the intent to remain permanently. That domicile, when you've come to a new nation, you say, I'm here to stay, you become part of their political community, and you become akin to a citizen. And that's reflected very strongly in the case I cited before.
And just to circle back to Justice Kagan's point, it's striking that in none of the debates do we have parents discussed. We have the child's citizenship and the focus of clauses on the child, not on the parents. And you don't see domicile mentioned in the debates. That's the absence is striking.
I think the 19th century sources would say a newborn child lacks the capacity to form a domicile, so they're imputed the domicile of their parents. So I don't think they would have seen a distinction between children and parents. And I point out that their position, like ours, is forced to look at the domicile of the parents because we look at the exceptions that they accept, like
I'm talking about
tribal Indians and so forth.
I'm talking about in the debates over the 14th Amendment and the Civil Rights Act. It's striking that these concepts aren't discussed in them.
I think domicile is discussed. I mean, it's brought up in many.
Allegiance, jurisdiction, complete jurisdiction.
Well, I mean, here's just a few examples. Page 1679 of the Congressional record, President Johnson vetoes the first version of the Civil Rights Act, and he says, I can't sign this because it would extend citizenship to the children of, quote, all domiciled aliens and foreigners, even if not naturalized. And you have all the other sources we cited that say, this is a deeply rooted 19th century understanding. It's reflected in the Venus. It's reflected in the Pizarro in 1814 and 1817. It carries through the 19th century, and this court is talking about it in 1892 and 1893 when it's discussing the Chinese Exclusion Tax. Domicile is the key concept that creates allegiance. That's
General,
so
you said in your reply brief that the children of slaves who were brought here unlawfully, in defiance of laws forbidding the slave trade, would in fact be citizens. And we can imagine that their parents were not only brought here in violation of United States law, but were here against their will, and so maybe felt allegiance to the countries where they were from. And you say that the purpose of the 14th Amendment was to put all slaves on equal footing, newly freed slaves on equal footing, and so they would be citizens. But that's not textual. So how do you get there? You say it in just a few sentences, so can you elaborate?
Sure. If you look at I think if you look at the 19th century sources, what you see is that even though their entry may have been unlawful, 19th century antebellum law never treated their presence as unlawful. In fact, quite the opposite. One of the amici, in fact, points to like a Mississippi statute, which probably is replicated throughout the South before the Civil War, that says slaves in Mississippi have an indefeasible domicile in Mississippi. In other words, even if they run away, if they get away, Mississippi says, nope, you still live here. right? And so it'd be astonishing, in other words, for the opponents of the 14th Amendment to say, oh, you know, these people were not domiciled and therefore it goes the other way, because actually U.S. law, even if they were brought in illegally and through an illegal slave trade, once they were there by
Well,
domestic
their
law,
intent is to return as soon as they can, let's say. So they're here, they're resident, and maybe under your theory, I mean, which says, well, lawfulness for a different purpose, but they're here, they're resident. Let's take your assumption that they're not here unlawfully. But let's say they don't have an intent to stay. They want to escape and go back the second they can. Are they domiciled?
Under the 19th century law, I mean, I think this is the flip side of the hypothetical that we were talking about earlier. Under 19th century law, they are treated as domiciled in the United States. So it'd be astonishing. And in the debates in the Congressional floor, talk about not this specific case, but to say, look, slaves who have been forced to come here and have been here are lawfully domiciled here. I mean, they don't use the ways domiciled like they use allegiance. They say they don't have allegiance that once they've been forced to come here, they don't have allegiance to any foreign or African potentate, and therefore they're.
General, that goes
How
to
would that
one-
apply to the children of illegally trafficked people today? Would the same reasoning apply?
It would turn on whether the parents are lawfully domiciled in the United States.
So if they're brought in illegally, but then they choose to remain and they want to remain and they're domiciled, you would say that their lawful presence is not dictated by whether they were brought here lawfully or not. And that's different from someone who, say, crosses the border unlawfully.
Yeah, I think it would turn on whether their presence is lawful.
General,
In other words, obviously there may be many other important things that could be done to assist people like that. The question is, if they give birth to someone in the United States, that person naturally a citizen, that would turn, based on the original public meaning of the clause, on the lawfulness of their presence. Are they domiciled?
General, can I ask you a question? To follow up on what Justice Gorsuch was exploring with you with respect to domicile, did I understand you to say that domicile is going to be eventually or is controlled by Congress? Who is domiciled? I'm struggling to figure out who is domiciled in your argument.
The domiciliaries are people who are lawfully present and have an intent to remain permanently. So that's a kind of black letter, understanding of domicile. Now, Congress can dictate that certain classes of people, legal entrants and so forth, cannot lawfully lack the legal capacity to form a legally binding domicile.
But if that's so, then doesn't it make the domicile for the purpose of the 14th Amendment turn then ultimately on Congress's will in a way that the framers did not intend? I mean, my understanding was the framers put this citizenship clause into the Constitution to prevent future Congresses from being able to affect citizenship in this way.
Sure.
Very briefly, no, I don't think so, because it is up to the alien whether or not they want to be domiciled here. Now, there may be
But I thought you just said Congress can make determinations as to who counts as being domiciled here.
Yeah,
So if that's true, then it ultimately would impact, in your theory, whether or not this person can claim that they have citizenship for 14th Amendment purposes based on Congress's determination. And I just thought that's what the 14th Amendment was trying to get away from.
if I may.
Yes, please.
Very briefly, I just point you to the discussion in Professor Werman's amicus brief where he talks about this is not a new problem. Going back even to the British common law, there's a situation of people who lack a safe conduct and are passing through the king's domains without permission. And he says the best reading of the common law is they are not under the protection of the king and they're not covered by the rule of birthright citizenship.
Thank you, counsel. You mentioned in your briefing and also this morning the problem of birth tourism. Do you have any information about how common that is or how significant a problem it is?
It's a great question. No one knows for sure. There's a March 9th letter from a number of members of Congress to DHS saying, do we have any information about this? The media reports indicate estimates could be over 1 million or 1.5 million from the People's Republic of China alone. The Congressional report that we cite in our brief talks about certain hotspots like Russian elites coming to Miami through these birth tourism companies. And I mean, here's a fact about it that I think is striking. Media reported as early as 2015 that based on Chinese media reports, there are 500 birth tourism companies in the People's Republic of China whose business is to bring people here to give birth and return to that nation.
Having said all that, you do agree that that has no impact on the legal analysis before us?
I think it's, I quote what Justice Scalia said in his Hamdan dissent, where like their interpretation has these implications that could not possibly have been approved by the 19th century framers of this amendment. I think that shows that they've made a mess. Their interpretation has made a mess of the provision.
Well, it certainly wasn't a problem in the 19th century.
No, but of course, we're in a new world now, as Justice Alito pointed out to, where 8 billion people are one plane ride away from having a child who's a U.S. citizen.
Well, it's a new world. It's the same Constitution.
It is, and as Justice Scalia said, I think in the case that Justice Alito was referring to, you've got a constitutional provision that addresses certain evils, and it should be extended to reasonably comparable evils. He said that about statutory interpretation. I think the same principle applies here, and I think we quote that in our brief.
Thank you. Justice Thomas, anything further?
Generally, you're getting a lot of questions about immigration, and they harken back, of course, to the citizenship, which is defined in or set out in the 14th Amendment. How much of the debates around the 14th Amendment had anything to do with immigration?
I think that the principal focus of those debates, it has to do really not with immigrants, but with the Indian tribes. I mean, obviously the main goal, the one pervading purpose, as this court said in the Slaughterhouse cases, was to establish the citizenship of the freed slaves and their children. But they were very concerned about the problem of something that they all accepted as a given, which is that the children of tribal Indians are not within the rule of birthright citizenship. So I think that's what they focus on. We draw an analogy to that, to the issue of temporary sojourners. And then, but there are mentions of temporary sojourning multiple places in the congressional debates, and all of those quotes go in our direction.
And there was, Justice Sotomayor brought up Wong Kim Ark. There was no question in that case that about domicile, was there?
I disagree. The court says at the very beginning of its opinion, here are the accepted facts. These are lawfully domiciled here. When it states the question presented, it talks about domicile. When it recites the legal principle at page 693, it says domicile 3 times. And at page 705 at the end of the opinion, it says, here's the single question we've decided. We've decided that Chinese immigrants with a permanent domicile and residence here fall within the rule of birthright citizenship.
Justice Alito?
Under the minimum definition of domicile, which I think existed in 1868 and continues to exist today, a person's domicile is the place where he or she intends to make a permanent home. Now, normally you would think that a person who is subject to arrest at any time and removal could not establish domicile. But we have an unusual situation here because our immigration laws have been ineffectively and in some instances unenthusiastically enforced by federal officials. So there are people who are subject to removal at any time if they are apprehended and they go through the proper procedures. But they have, in their minds, made a permanent home here and have established roots. And that raises a humanitarian problem. And I wonder if you could address that.
If I may, one legal and one humanitarian. The legal point is, if you look at those cases, for example, Carson against Reed, Park against Barr, this court's decisions in Elkins and Toll against Marino, they talk about the legal capacity to create a domicile, excluding someone who may have the subjective intent, which otherwise would be determinative, as being excluded. On the humanitarian point, I would point out, as I said at the beginning, Justice Alito, that the United States rule of nearly unrestricted birthright citizenship is an outlier among modern nations. It's a very small minority of nations that have that rule. For example, every nation in Europe has a different rule. And the notion that they have a huge humanitarian crisis as a result of not having unrestricted birthright citizenship, I don't think is a strong argument. And I point out, obviously, for reliance-related reasons, this executive order applies only prospectively, and we ask the court to rule only prospectively.
Justice Sotomayor?
I agree with you what the European nation's rule is, but England was always different, wasn't it?
Not until 1983 it changed to the
That's not quite true. The Wong Kim Ark does a wonderful job of laying out the English rule. And you claim it was different, but there isn't any treatises or scholars who say it's different. English rule was always by birth. Other countries were not by birth. Let me just go to the implications of what you're asking us to do. You are asking us to overrule Wong Kim Ark. Well, Wong Kim Ark's parents were domiciled in the US, but they owed loyalty to China. They eventually returned to China. So they didn't have a primary allegiance to the United States. So you're not asking that. Are you asking us to overrule then our cases, one of which said that a child of illegal aliens was a citizen? You're asking us to overrule that.
No, first of all, we're not asking you to overrule Wong Kim Ark. We agree
you
with the
are
holding of
asking
Wong
us
Kim Ark
to-
in much of the reasoning. And then as to those later cases starting in 1966, where the court makes sort of, unreasoned references to this
Wait a
issue,
minute,
we think
Top Ulus, the respondent unlawfully overstayed her visa and gave birth to a child here. The court, Harlan II, wrote, the child is of course an American citizen. That person wasn't domiciled here lawfully. So you're asking us to overrule that case.
I wouldn't say we're asking you to overrule. We think that's similar to a drive-by jurisdictional ruling where there's a simple statement that's not debated. There's no further analysis of it. There's really an assumption there. And we think that's similar to cases where the court just assumes jurisdiction without discussing it.
When we ruled in Trind that Indians could not become citizens, the government then after began to unnaturalize many Indians who had been sworn in as citizens. You asked us to concentrate only on the prospective nature of the citizen's order. But the logic of your position, if accepted, is that this president or the next president or a Congress or someone else could decide that it shouldn't be prospective. There would be nothing limiting that, according to your theory.
If, as we asked, the court confines its ruling to prospective relief only, which it did in
No, I'm
Sessions
saying
against.
to you, that's what you're asking us for relief right now. I'm asking whether the logic of your theory would permit what happened after the court's decision in Trin, that the government could move to unnaturalize people who were born here of illegal residents.
No, we believe the court should do what it did in Sessions against Morales-Santana, where there was a ruling that would have deprived people who are already citizens of citizenship, and the court said this applies prospectively only, and we think that's the appropriate course here.
But that's not what we did in Trin.
We think that Sessions provides the proper course here, and that's what we're asking. We are not asking for any retroactive relief.
Justice Kagan?
General, I think even your brief concedes that the position you're taking now is a revisionist one with respect to a substantial part of our history. And I think that that's in large part because of Wong Kim Ark and the way people have read that case, which of course was in the late 19th century, and have read it ever since then. And what that case suggests is, there's a very clear rationale. You say, oh, it says the word domicile a bunch of times, which it does. It's a long opinion. It says a lot of things. But the rationale of the case is really quite clear. It says there was this common law tradition. It came from England. We know what it was. Everybody got citizenship by birth, except for a few discrete categories, which were the ones that the Chief Justice mentioned at the beginning. And that tradition carried over to the United States. And then what the 14th Amendment did was accept that tradition and not attempt to place any limitations on it. And so that was the clear rationale, a clear rationale that is diametrically different from your rationale. And everybody took Wong Kim Ark to say that and to say that as a result of that, of course, birthright citizenship was the rule. And I think everybody has believed that for a long, long time. And I guess my question is this. You have a story about what about the reasons why we should go back to what you view as the original meaning. And given the long history of this country's understanding about birthright citizenship, what would it take? What do you think it should take to accept that story in terms of the magnitude of the evidence that we would need to see in order to accept this revisionist theory and in order to change what I think people have thought the rule was for more than a century?
Let me make 2 points in response to that, one historical and one legal. Historical point, I disagree with the way you've characterized the understanding of Wong Kim Ark, and I would point to something that's emphasized. 21 was a senior State Department official in the Roosevelt administration and pushes their theory as to temporary sojourners, writes a law review article in 1921 where he says, I think the children of temporary visitors should be citizens. But he admits that is not the understanding of Wong Kim Ark. He admits Wong Kim Ark did not hold that. And he admits that there's an array of authorities that go against him. He talks about careful and reliable, high authorities. And that's referring to the consensus that we point out in pages 26, 28 of our brief. We've got 12 treatises from 1881 to 1922 that all say, including for decades after Wong Kim Ark, that say children of temporary sojourners are not included. What happens between 1921 and the 1930s? Well, Mr. Flournoy became a senior State Department official, and he adopted that as the policy of the Roosevelt administration. So their argument is basically saying there wasn't this consensus going back to issue here, and was not an issue in Wong Kim Ark, is the children of temporary visitors do not become citizens under the clause. And then the legal point, you referred to this sort of concept of temporary local allegiance, and they rely on the Schooner Exchange, this theory that you've got temporary local allegiance. But if you actually look at page 572 of the Congressional Record, right at the beginning, introducing the Civil Rights Act, Senator Trumbull says, I said not subject to any foreign power. I wanted to say born in the United States and, owing allegiance to the United States, but I was aware that there's a, quote, a sort of allegiance from persons temporarily resident in the United States whom we have no right to make citizens. So Senator Trumbull says the reason I haven't adopted the language and meaning that they say should be packed into these provisions is that everybody knows that the children of temporary visitors should not be citizens.
Thank you, General.
Justice Gorsuch?
Just to follow up on that point, General, one interesting counterpoint about the understanding of Wong Kim Ark that followed with respect to temporary sojourners. And I take you've got your well-taken points. But there was, of course, John Marshall Harlan, the great dissenter who descended in Wong Kim Ark and later gave a bunch of lectures. And he posed the question about the sojourners. Suppose an English father and mother went down to the hot springs to get rid of the gout. And while there, they have a child, now back in England. Is that child a citizen of the United States, born of the jurisdiction thereof by mere accident of birth? And he says, under Wong Kim Ark, he is. And he continues, I was one of the minority, and of course I was wrong. Now, I'm sure that was tongue-in-cheek, but now what do you do with that?
I'd say two things in response to that. First of all, he gave a speech, but we have 12 uncontradicted treatises that say the opposite, that is not what Wong Kim Ark means, and that's not the meaning of the clause. But also, I make a more fundamental point. When you're looking at Wong Kim Ark, one of the dissent has this dominant theme that really like you can't be doing this because you can't make and we all agree do not become citizens. And how does the majority opinion address that? It says domicile 3 times when it recites the legal rule. It says permanent residence and domicile when it decides the holding. So the court should be bound by what it says. This is what we're deciding. And again, on page 75, it says this is the single question. Now, there's been a lot of discussion up to that point, but at the very end, they said the single question we decided is the citizenship status of the children of Chinese immigrants with a permanent residence and domicile in the United States.
Do you think Native Americans today are birthright citizens under your test and under your friend's test?
I think so. I mean, obviously they've been granted citizenship by
Put
statute.
aside the statute. You think they're birthright citizens?
No, I think the clear understanding that everybody agrees in the congressional debates is that the children of tribal Indians are not birthright
I
citizens.
understand that's what they said, but your test is the domicile of the parents. And that would be the test you'd have us apply today, right?
Yes, yes. So if a tribal Indian, for example,
Are
you know,
tribal
gives up
members
allegiance to,
born today, birthright citizens.
I think so on our test. Yeah. If they're lawfully domiciled here.
Okay.
I'm
And then
not sure, I have to think that through, but
that's
my reaction.
I'll take the yes. That's all right. And then I just want to ask you quickly about the INA adopted in 1940 and 1952. It uses the same term as the Citizenship Clause, and one might have a pretty good argument. I'm sure you got some arguments along just these lines that it should be understood to mean whatever it meant in 1868. But there was a lot of water over the dam between those two things. And as your brief points out, by the Roosevelt administration, there's a pretty strong jus soli move. That is to say that the thin concept of jurisdiction, power over, is enough, a broader understanding of birthright. Would there be an argument for reading that statute under its original plain meaning at the time, 1940, 1952, to perhaps have a different meaning than the Constitution?
We don't think that's the best interpretation. I give two reasons. One is it would be very surprising if a statute that says exactly the constitutional phrase subject to the jurisdiction thereof were interpreted to mean something totally different or to ossify a then current misunderstanding of the clause. We think that the best analogy here is probably state long-arm statutes. Take a sort of non-controversial example. State long-arm statutes routinely say we're going to exercise personal jurisdiction to the extent of due process. It takes the constitutional standard and it puts it in the statute, and nobody thinks that those ossify, or do the precedent, this court's precedents at the time they were enacted. Everyone thinks that that phrase due process incorporates, the developing law of due process and minimum context and so forth, including from this court. So we think that's the best analogy when you're looking at the constitutional phrase itself and you take it out of a freighted context. The natural interpretation is say this means what this reflects the objective meaning of the Constitution, and the objective meaning of the Constitution is its original public meaning in 1866.
Do you see any notable counterpoints to that argument?
I'm sure there are arguments on the other side. We addressed them in their brief.
So you're really, at the end of the day, then, this is a straight up constitutional ruling you want from this court, win, lose, or draw?
Yeah, we think that the statute and the Constitution means the same thing. If the court disagrees, obviously we prefer an adverse ruling if the court's going to do that on a statutory basis than a constitutional basis.
But you just disavowed that in your responses to me by saying that that's not an available option. Is the way I understood it.
Yes, the court would have to disagree with our statutory position, which is that it means the same thing as the Constitution. But if the court were to do that, then the natural course would probably be to rule on statutory grounds alone. Now, we think they mean the same thing, and we've got arguments for that, including, I think, the analogy I just referenced.
Thank you.
Justice Kavanaugh?
General, how should we think about the text of the 14th Amendment subject to the jurisdiction thereof as distinct from the different language of the Civil Rights Act of 1866, which refers, as you know, to persons not subject to any foreign power? Those texts are on their face different, and the history that Justice Kagan referred to might have developed quite a bit differently if the 14th Amendment's text had used the phrase that was in the Civil Rights Act.
That's an excellent point, and this court has held in multiple cases, Heard against Hodge and General Building Contractors has recognized that they were intended and they did mean the same thing, and that's powerfully reinforced by the congressional debates, where really what they're discussing is they said they were dissatisfied with the language in the Civil Rights Act because the phrase Indians not taxed they thought was ambiguous, and so they switched to the affirmative statement as opposed to the negative statement. The affirmative statement is subject to the jurisdiction thereof, but there's express statements in the congressional record essentially that we're doing the same thing. And that is what this court's case law has reflected.
Why didn't they say the same thing?
Again, it appears they preferred the sort of positive formulation subject to the jurisdiction thereof as opposed to not subject to any foreign power. And again, there's a deep concern and lengthy discussion of the potential ambiguity in the Civil Rights Act. They want to eliminate an ambiguity, but do the same thing. And I think that that's very strongly reflected in those debates.
By the time of the 1940 and 1952 congressional actions, where Congress repeats subject to the jurisdiction thereof, given Wong Kim Ark, one might have expected Congress to use a different phrase if it wanted to try to disagree with Wong Kim Ark on what the scope of birthright citizenship, same language, knowing what the interpretation had been. So how are we to think about that?
I think baked into that question is an understanding, I think that was reflected in Justice Kagan's earlier question, that everybody understood that Wong Kim Ark meant that, and the history I talked about, I think refutes that really there's a consensus that goes our way for decades and decades after the adoption of the amendment and after Wong Kim Ark on the specific question of the children of temporary visitors. And it's really not until, and again, their author in 1921 is saying, hey, the other side is the consensus.
I'm sorry.
Sorry, go ahead.
But there's executive branch interpretations and others. And if you're in Congress in 1940 and 1952 and you want to limit the scope of Wong Kim Ark or to eliminate ambiguity, why do you repeat the same language rather than choosing something different? For example, you could use the language from the Civil Rights Act of 1866 or some similar formulation if your idea in 1940 and 1952 was to not have ambiguity or not have an overly broad scope.
I think if you look at the structure of that statute where it's 1401A and then B through H, A, and it says these are the people who are entitled to birthright citizenship. A is the constitutional standard, and then B through H are all the categories that Congress has super added to that. I think the natural inference is that Congress is codifying, which it was consciously doing in 1941, pulling all the naturalization rules and immigration rules together into one statute and said, you go to one place, here's who is a birthright citizen. A, those who are guaranteed that right by the citizenship clause, and B through H are the ones that Congress has added through its naturalization power. So that inference to me says, A is merely, it's not trying to change or alter the constitutional standard, it's just saying, hey, the baseline is what the Constitution says, and we codify that, and then we move on to the new categories.
Of what relevance, if any, do you think Section 5 of the 14th Amendment has here that gives Congress the power to enforce the article, the 14th Amendment, by appropriate legislation? Does that give Congress room here, or do you not think so?
I do think that a ruling in our favor would leave room for Congress. I don't think you'd have to rely on section. I think that Congress has its own inherent power to grant citizenship by statute. So if the court were to rule in our favor for the classes of individuals that they say should be covered, Congress has the latitude to do that.
How much room do you think Section 5 gives, if any, and it may not be any, Congress to interpret the phrase subject to the jurisdiction thereof, or to define that? Is that relevant at all?
It's a great question, and I'm thinking about it for the first time. I assume it would be governed by the congruence and proportionality test from this court's case law. How that would apply here, I don't know. And I don't think it's presented because our contention is that the statute means exactly the same thing. If anything is congruent and proportional, it's that. And I think the court held that in the United States against Georgia.
You've mentioned several times the practices of other countries, and that's obviously, as a policy matter, supports what you're arguing here, but obviously we try to interpret American law with American precedent based on American history. That's certainly what I try to do, and I think you try to do. And so why should we be thinking about, even though as a policy matter I get the point, thinking about, gee, European countries don't have this, or most other countries, many other countries in the world don't have this, doesn't that? I guess I'm not seeing the relevance as a legal constitutional interpretive matter necessarily, although I understand it's a very good point as a policy matter.
Yeah, I largely agree with that, and you can view it as being raised preemptively, defensively. I'm going first, but obviously the other side of their amici say, make it a prediction, end of the world type predictions, and our point is, it's a very small minority of countries. Almost every country, and certainly all European countries, have a different rule, and the world hasn't ended there.
The other side, last one, the other side relies heavily, of course, on Wong Kim Ark, and you disagree with their interpretation. Oftentimes, when you are dealing with a constitutional precedent like this, you might argue, we disagree with that interpretation, but if you adopt their interpretation or agree with their interpretation of that precedent, you should overrule it. And you haven't made that argument here, and I'm just giving you an opportunity to explain why you haven't.
Because we think it's totally unambiguous in Wong Kim Ark that the holding is relates to domiciled aliens. And so we strongly agree with the holding. We think domicile was the touchstone, and we think that's not a coincidence for the reason that I maybe speculate a little bit when I was talking to Justice Gorsuch about how the dissent raises this, and then the majority is like, we're putting domicile in there, so we know that the absurd conclusion that they say would come from this isn't there. But also domicile as kind of the sort of relationship that creates this relationship of allegiance that makes you part of a political community if you're an alien from another country. That's deeply rooted in their understanding when they're doing it. They talk about domicile in Yikwo against Hopkins in the 1892 and 1893 cases, and there's this deeply rooted understanding again that goes all the way back to the early 19th century. So we think that's a really important conception. So I mean, we disagree with some of the dicta in Wong Kim Ark that we discuss, and we think there's dicta that goes our way that the other side overlooks. And we're not asking the court to overrule dicta. We just say don't follow erroneous dicta and don't apply it to this brand new situation that was not decided in Wong Kim Ark.
Thank you.
Justice Barrett?
So General Sarr, I want to zoom out a little bit and think about jus soli and jus sanguinis. So as I understand it, at the time of the 14th Amendment, those were the two dominant approaches. Jus soli, the English common law, roughly following the soil, jus sanguinis, roughly citizenship following the parents. Now, jus soli was very generous on the soil, the English common law, and so it extended citizenship to those born there who may not have been born of parent citizens. But jus sanguinis, if parents who are citizens and had a child abroad, then that child's citizenship followed the parents. So one thing that's puzzling me about your argument when I think about the ratification of the 14th Amendment, in many ways it would have made sense for them, and you acknowledge the jus sanguinis in citing Vattel. It would have made sense in some ways for them to say, okay, we're going to follow, if they wanted to accomplish what you're saying they wanted to accomplish. You could say, well, we're going to follow jus sanguinis because we're going to make it all ride on parentage. But instead, I mean, the 14th Amendment, we're talking about subject to the jurisdiction thereof, but it also says born in the United States. So you have the jus soli kind of point there, but you're saying it narrowed that point by tying it to the citizenship of the parents, at least as to soil. But I take it you're not arguing that United States citizens who have children born abroad would qualify for birthright citizenship. So it's kind of a narrower view of both the traditional jus soli rule and a narrower view of the jus sanguinis rule. So why would they have done that? And if they were going to invent an entirely new kind of citizenship, like an American brand, why wouldn't we have seen more discussion of that in the debates?
I just want to take this opportunity to say, aren't you all proud of me that I'm not interrupting at all? I'm proud of me. So anyway, I'm not going to interrupt the Supreme Court anymore. I know my place. We'll go ahead and let them continue speaking, but I think you all should be proud of me. Okay, let's get back to the broadcast.
Allegiance.
Yeah, I'm not sure that that's true of the 19th
It seems
century
a little
sources,
ambiguous,
but
and I'm going to ask your friend on the other side that question.
let me point out then that there are two criteria. One is birth on the soil, and the other is allegiance or allegiance. What we have is birth on the soil remains the same, right? And so they are, and that's why so much of Wong Kim Ark is actually we agree with, because they are adopting a modified British rule. They are not going the French rule, that Vattel talks about, where it's like who's the citizen. That had to be done by statute, as you pointed out, which it was in 1401. But what they've got is they say birth in the United States and subject to the jurisdiction thereof. That is talked about as allegiance, allegiance, allegiance in the congressional debates, but they were clearly not incorporating the British feudal monarchical conception of allegiance where it's indefeasible. I mean, going back to the early 1700s, our nation had repudiated the notion that citizenship is indefeasible. The expatriation statutes for the late 1700s reflect that. And again, you look at the 1868 congressional report that we cite there, this is the same group of congressmen, Republican congressmen, and they say things like the U.S. Constitution itself is proof that Blackstone's theory of allegiance was not accepted. So they accept birth on U.S. soil, but then they take the concept of allegiance and give it its Republican, Democratic, American understanding. And that's very, very, I think that makes a ton of sense.
Okay, let's talk about its applications. So, there are some, I can imagine it being messy in some applications. So what would you do with what the common law called foundlings? The thing about this is then you have to adjudicate. If you're looking at parents, and if you're looking at parents' domicile, then you have to adjudicate both residence and intent to stay. What if you don't know who the parents are?
I think there are marginal cases. That one, I think, has the benefit of being addressed in 1401F, where it talks about.
Yeah. But what about the Constitution?
Under the Constitution, I mean, look, domicile is a constitutional standard in all kinds of other situations.
Well, and it's hard.
Diversity jurisdiction, personal jurisdiction, sorry.
Well, yeah, and a personal jurisdiction, I mean, 1332, diversity jurisdiction. And the thing is, it has to be litigated because it turns on intent. And both the virtue of both jus soli and jus sanguinis, whichever one you pick, it's a bright line rule. How would it work? How would you adjudicate these cases? You're not going to know at the time of birth for some people whether they have the intent to stay or not, including U.S. citizens, by the way. I mean, what if you have someone who is living in Norway with their husband and family, but is still a U.S. citizen, comes home and has her child here and goes back? How do we know whether the child is a U.S. citizen because the parent didn't have an intent to stay?
I'd say make 2 points, one practical, one legal. The practical point is under the terms of this executive order, you don't have to, because the executive order turns on objectively verifiable things, which is immigration status. Are you lawfully present but temporarily present, or do you have an illegal status? So those kind of taking evidence, so to speak, under subjective intent wouldn't be done. And as to the constitutional point, obviously domicile is baked into a lot of constitutional and legal concepts, and there may be situations where facts are determined. But if you look at the guidance that all the agencies did after this court in Costa said the agency could go forward to issue guidance, the guidance provides, I think, very, very clear, objective, verifiable approaches to doing this. And so as a practical matter, I don't think it's presented by this executive order.
Thank you, General.
Justice Jackson?
Good morning, General. So I guess I am looking at your position in this case, and it boils down to requiring us to do at least these two things. One is believe that the framers were not importing the common law rule and understanding of birthright citizenship. And the second is to believe that what they were doing was departing from that common law rule in the way that you suggest. That is, they were seeking to have this turn on domicile. I think you have a number of hurdles to accomplish those two things. One of which I think is that when we look at this court's case law, and no one I think has mentioned Schooner's Exchange, but it appears that that was an 1812 case in which it seems as though the court had already accepted at the time of the ratification of the 14th Amendment that the allegiance that you were talking about was the English common law rule. That, in other words, allegiance meant that you are covered by the laws of the jurisdiction, that you can rely on that jurisdiction's protection. That's what allegiance meant. Now, you're saying today, no, allegiance meant something about loyalty or that kind of idea. But if the Supreme Court had, prior to the 14th Amendment, established that allegiance meant the common law definition, I think your first hurdle is to help us understand why we would believe that when the 14th Amendment was ratified, the framers weren't just incorporating what we had previously said it meant.
Page 572 of the Congressional record directly addresses this. They say the concept of temporary and local allegiance from the Schooner Exchange is what is meant by, or temporary and local jurisdiction from the Schooner Exchange is what is meant by the word jurisdiction in the 14th Amendment. Senator Trumbull says, I thought about saying owing allegiance, but again, quote, there's a sort of allegiance from persons temporarily resident in the United States whom we have no right to make citizens. So he expressly and consciously rejected reliance on Schooner.
What do we do with, I mean, that's a debate and it's a discussion, very valid, but then we have a subsequent debate between Fessenden and Wade where the same concept comes up and it becomes clear, at least from Senator Wade's perspective, that that's wrong. So Fessenden, and I'm not sure whether these are senators, I apologize. Fessenden says, suppose a person is born here of parents from abroad temporarily in this country. Wade responds, the senator says a person may be born here and not be a citizen. I know that is so in one instance, in the case of the children of foreign ministers who reside near the United States, et cetera, et cetera. So it appears as though in that exchange, at least Senator Wade believed that the English common law understanding of what it means to have allegiance, to be a temporary person on the soil, was what was being adopted.
Yeah, that exchange strongly supports us. If you look at it in context, Senator Wade has introduced a version that says only birth on U.S. soil and doesn't have any allegiance or jurisdictional element to it. And so Senator Fessenden stands up and says, well, that can't be right, because obviously, what about the children of temporary visitors? It has this, it's another one of these statements that has this appeal to a background understanding that we all agree that the temporary visitors, their children do not become citizens. And then Senator Wade has to kind of backtrack and say, well, what are the children of ambassadors? And in the end, Congress does not adopt Senator Wade's proposal. So we think that to the extent you can draw an inference from that, the inference strongly supports.
All right, well, let me just ask you about why we wouldn't see in the 14th Amendment anything about parental allegiance. Several of my colleagues have talked about the fact that your view of this turns on what the status of the parents are, and not the child, as would the born in the United States view of it. How can you help us understand why we wouldn't expect to see a mention of parents in the text? Assumes domicile is in the test, and I'm asking you, how do we know that Congress did adopt the test that you say it adopted?
Yeah, when you're looking at 19th century conceptions of allegiance, the notion that the allegiance, again, we say domicile is instantiating the concept of allegiance for aliens as opposed to citizen. All of that, the 19th century understands the newborn's domicile, its allegiance follows the allegiance of the parents. And I point out that their theory relies on parental allegiance as well, because they recognize the exceptions for, hostile invading armies, for tribal Indians, for ambassadors. Again, the child's allegiance status, even on their view, turns on the status of the parent.
What do we do with Professor Muller's amicus brief and the historical record, and the fact that even at times in this country where we understood that the parents were declared enemies of the United States, I'm talking about World War II and Japanese internment, babies born in that circumstance were given birthright citizenship. So it seems as though this concept of allegiance of the parents really wasn't driving birthright citizenship, at least at this period of our history. So are you saying this is wrong, or they shouldn't have gotten birthright citizenship?
Well, if they were domiciled here, yes, they should have. If they were temporarily present, then no. But the executive practice, we can see from the 1930s.
How does the temporary presence run with your concept of allegiance? I'm not sure I understand. So can you be clear? Are you saying that only people who are domiciled here, as you define it, can form the necessary loyalty to the United States?
It's not allegiance is not a question of subjective loyalty.
Okay.
It is something you owe. It's a reciprocal relationship between the citizen, whether they want it or not, they have that allegiance. And I think it's powerfully—
On the basis of what?
Domicile. I mean, that's what it says in so many words in the Venus and the Pizarro. It says, look, if you're talking about an alien, if they're just temporarily passing through, no, they don't have allegiance. But if they've made it their permanent home, they become part of our political community, and they are analogous or akin to citizens.
All right, just quickly, because I'm mindful of the time. What do you do with Wong Kim Ark's statement that birthright citizenship is applying, quote, independently of a residence with intention to continue such residence, independently of any domiciliation? I know that they use domicile, it's a fact in the case, but that's not a part of their holding. It's not what the reasoning turns on. Correct?
I believe you're quoting from page 693 of that opinion. It goes on to say, not citizen terms on that, but the duty of obedience to our laws. It doesn't take the further step at that point and say, therefore, if you have temporary and local allegiance, you're a citizen. And immediately before that, you have that page 693 summary of the court's holding, where it says
you say Wong Kim Ark incorporates a domicile requirement.
That is the holding. It's definitely clearly expressed in the holding.
All right, one final thing, perspective. You say perspective, we're supposed to do this. Don't worry about the people who are already here and who would not qualify under your rule. How does this work? Are you suggesting that when a baby is born, people have to have documents, present documents? Is this happening in the delivery room? How are we determining when or whether a newborn child is a citizen of the United States under your rule?
And I think that's directly addressed in the SSA guidance that's cited in our brief. What SSA says is there's currently a system where, for example, social security numbers are generated based on the birth certificate. They say this can still be, for the vast majority of instances, completely transparent. You will still get a...
No, not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So we bringing pregnant women in for depositions. What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So if you give birth to a baby in the hospital right now, it gets the birth certificate in the system. There's a computer system.
So there's no opportunity, there's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States.
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which would only happen in a tiny minority of cases,
after the
is
fact.
directly addressed in that guidance.
After the fact,
Yes.
after their baby has been denied citizenship, then we can go through the process.
And the way that, I mean, I'm summarizing because I'm not an expert
Yes.
in computers, but there's a computer program that currently automatically generates a social security number. SSA says, look, a social security number, non-citizens can have them if they have work authorization, so it doesn't prove citizenship. We'll give you a social security number, provided that there's the system automatically checks the immigration status of the parents, which there are robust databases for, and then it appears no different to the vast majority of birthing parents.
Thank you.
Thank you, counsel. Ms. Wong?
Mr. Chief Justice, and may it please the court, ask any American what our citizenship rule is, and they'll tell you, everyone born here is a citizen alike. That rule
Now,
is
this
enshrined in
is
the 14th
the
Amendment
people who are
to put it out of the
pro
reach of any government wishing to destroy.
birthright
When the
citizenship.
government
That's where
tried
we are
to
now.
strip Mr. Wong Kim Ark's citizenship on largely the same grounds they raised today, this court said no. 30 years after ratification, this court held that the 14th Amendment embodies the English common law rule. Virtually everyone born on US soil is subject to its jurisdiction and is a citizen. It excludes only those cloaked with a fiction of extraterritoriality because they are subject to another sovereign's jurisdiction, even when they're in the United States. A closed set of exceptions to an otherwise universal rule. My friend has now clearly said that the government is not asking you to overrule Wong Kim Ark. That is a fatal concession, because Wong Kim Ark's controlling rule of decision precludes their parental domicile requirement. The dissent understood that, and the majority tells us 6 times in the opinion that domicile is irrelevant under common law. Lynch versus Clark was already the dominant American case on citizenship, and it held that the US-born daughter of temporary visitors from Ireland who took the baby back to Ireland with them, that daughter was a US citizen. Authorities, including Lincoln's Attorney General and Kent's commentaries, embraced Lynch, and Kent specifically talked about temporary sojourners' children being US citizens. Justice Field said in 1884 that reflected the general understanding. That understanding was confirmed by Congress with its 1940 Act. The 14th Amendment's fixed bright line rule has contributed to the growth and thriving of our nation. It comes from text and history. It is workable and it prevents manipulation. The executive order fails on all those counts. Swaths of American laws would be rendered senseless. Thousands of American babies will immediately lose their citizenship. And if you credit the government's theory, the citizenship of millions of Americans, past, present, and future, could be called into question. All of this tells us the government's theory is wrong. I welcome the court's questions.
There are 5 exceptions to citizenship that you do accept.
Yes, depending on how many you count, Justice Thomas, how you count them.
What is the underlying rule of law that you use to connect these 5 exceptions?
Sure. So as I just said, all of the exceptions involve situations where that US-born child is not subject to the jurisdiction of the United States because that extraterritoriality, that fiction of extraterritoriality, the interaction of another sovereign between the United States' jurisdiction and that person applies to the child as well as to the parent. Everyone else born in the United States is subject to the United States' jurisdiction. To answer Justice Barrett's question to my friend, that's what sets those exceptions apart from other US born persons.
We've heard a lot of talk about Wong Kim Ark, and you dismiss the use of the word domicile in it. It appears in the opinion 20 different times, and including in the question presented and in the actual legal holding. And the government doesn't want it to be overruled because it's willing to rely on that particular fact in that case. Isn't it at least something to be concerned about, to say that since it's discussed 20 different times and has that significant role in the opinion, that you can just dismiss it as irrelevant?
Well, Mr. Chief Justice, I think we have to look at what the controlling rule of decision is in Wong Kim Ark. Justice Gray takes pains in the majority opinion to set out his analysis. He first starts with a premise that in construing the 14th Amendment Citizenship Clause, we look to the English common law. That was the rule that applied from the colonial era on, at least for the colonists and for European immigrants. He then says, look, Chief Justice Marshall tells us in the Schooner Exchange what subject to the jurisdiction means. Again, looking to the English common law. Under English common law, if you are born in the dominions of the sovereign, you owe natural allegiance. And those who are present in the dominions of the sovereign owe temporary allegiance for as long as they're present. The only exceptions, again, at common law were ambassadors, people born on foreign ships, and people who were born during periods of foreign occupation. He then gets to the government's favorite page, 693, where he says, look, we have had this rule in the United States as to citizenship, at least for white Americans, from before independence. The purpose of the 14th Amendment was to embrace that universal rule of birthright citizenship, to embrace and incorporate the common law exceptions with the single additional exception of the pre-existing exception for tribal Indians that we had in the United States, which is an analogous exception, and that's the closed set of exceptions. You can't make sense of the holding in the case without looking to the controlling rule of decision, which is the common law. And I think my friend agrees that under English common law, domicile was not relevant, and the children born to temporary visitors in the territory of the sovereign were always considered birthright citizens.
Well, Ms. Wong, I mean, everything you say strikes me as, yeah, that's the way I read it too. But then what are those 20 domicile words doing there? Like you can, take some of them and say, they were just summarizing the facts of the case, but not all of them. And why did they keep on, why did they sprinkle that in the opinion?
Well, I think, again, those were the stipulated facts in the case. And it's clear we have textual evidence in the majority opinion that they were simply saying this is an a fortiori application of that controlling rule that comes from the English common law. Justice Gray writes, again, after setting out the English common law rule and the exceptions with the single additional exception for children of members of Indian tribes, that the amendment in clear words and manifest intent includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. And as was pointed out earlier, the very next part of that same paragraph, he cites to Webster talking about Thrasher's case. And he says, people who are born in this country owe allegiance independently of a residence within, foreign nationals owe allegiance independently of a residence with intention to continue such residence, independently of any domiciliation, and independently of taking any oath of allegiance, which is totally contrary to both the government's theory of dual allegiance or partial allegiance and to the theory of domiciliation.
I mean, I might agree with you if domicile had simply been sprinkled in the opinion, but in Wong Kim Ark, it's a long opinion, but it begins by saying, here's the question, And it ends by coming back to the question. And it says, here's the question stated at the beginning of the opinion, namely whether a child born in the United States of parents of Chinese descent who at the time of his birth are subjects of the Emperor of China, but have a permanent domicile and residence in the United States and are there carrying on business, and he states the diplomatic exception, and he says, for the reasons above stated, this court is of the opinion that the question must be answered in the affirmative. So why put domicile in? Sometimes it's hard to figure out what is the holding of the case. Here he tells us this is the holding of the case. Why put domicile in there? It's just something, it's something irrelevant that he wanted to throw in. It's like, whether a child born in the United States of parents of Chinese descent who once resided at a particular address in San Francisco, who attempted to enter the country at the port of San Francisco. Why put it in if it's irrelevant?
Well, Justice Alito, I'll give you two responses. The first is that, again, it was a stipulated fact. The second is that regardless of what the judgment in the case was, which again was an a fortiori application of the rule of decision, the rule of decision in Wong Kim Ark has binding precedential effect. Even if you think that Wong Kim Ark decided the case based on the stipulated facts, you have to follow that controlling rule of decision. And if you follow that rule, you get to the same result for people without domicile. Wong Kim Ark says 6 times in the first parts of the opinion, as well as on the page the government focuses on, that domicile is not relevant.
Well,
that
Ms. Wong, on that, what do we do with the fact that after Wong Kim Ark, at least some authorities took the view that the non-domiciliary question wasn't decided, remained open, and even continued to press the view that domicile is required? Now, I know you've got a lot of good stuff on your side too, but what do we do with the fact that many sound legal authorities thought it remained an open question, even if one of them wasn't John Marshall Harlan?
I liked your example from Justice Harlan's lecture here in DC. So here's what I would say. All of the government's citations in their brief generally either were rejected by Wong Kim Ark expressly if they predated Wong Kim Ark.
If we're trying to understand how the legal community understood what happened in Wong Kim Ark, it seems to me it's a mess. So maybe you can persuade me otherwise.
I think I can, Justice Gorsuch. First, as to the post-Wong Kim Ark authorities the government cites, each one of them is inconsistent with Wong Kim Ark's reasoning or doesn't mention it at all. Most of them have very little reasoning at all. And in contrast, what we have on our side post-Wong Kim Ark is numerous federal court decisions around the time of Wong Kim Ark, between ratification and Wong Kim Ark, that said that domicile is not relevant. They cited Lynch versus Clark, which again was about the daughter of temporary sojourners. We have the 6th edition of Kent, which was cited in Wong Kim Ark, and of course was then cited after Wong Kim Ark was decided by many authorities, again, discussing temporary sojourners. Anyone who wanted to know what the law of citizenship was under the 14th Amendment after Wong Kim Ark would go to the 6th edition of Kent, where he says in that footnote on page 38 that the rule was Lynch versus Clark and temporary sojourners' children are US citizens. We have members of Congress speaking on the record on debates on immigration laws, where they were finally passing these immigration restrictions that Senator Cowan wanted. And they all stated either that Lynch was the rule, that Attorney General Bates had stated the rule, again, citing Lynch, or Kent, and stating the rule that everyone born in the US is a citizen, and saying, look, children of Chinese immigrants, these immigrants who are unwelcome, these immigrants that Congress is now trying to bar from entering the United States, if their children born in the United States are citizens. We have in 1896, so a couple years before Wong Kim Ark, but in 1896 State Department regulation, which said the US born children of foreign nationals are US citizens, accepting only the children of ambassadors. And then you have Marshall Woodworth, who is a US attorney who writes in a law review article that he's talking specifically about temporary sojourners' children, and he says, I don't think that's a good rule from a policy perspective, but that's the general rule.
Ms. Wang, can I, can I offer a possible explanation for why Justice Gray made a point of putting domicile in what he said was the holding of the case? And it is this. Wong Kim Ark and his parents, had they come to the United States from Europe, could have been naturalized. But because they were Chinese, they could not be naturalized. And they had done everything that they could to make themselves Americans by establishing a domicile in the United States. And so that's what this was about. He couldn't get naturalized because of a racist law, but they had done everything they could to become part of the American society. At the same time, there were many, many men who were horribly exploited, brought to the United States to work on the Transcontinental Railroad, to work in mines. They were worked to death. They were treated horrifically, but they were not, they were overwhelmingly men. There wasn't an indication that they would stay here, they could stay here, they didn't have permanent homes. And the opinion is drawing a distinction between those two categories of people who would have been well understood at the time when Wong Kim Ark was decided.
No, Justice Alito, I don't think that's a plausible explanation for why domicile is mentioned in Wong Kim Ark, because again, the controlling rule of decision based on the English common law and cases from Schooner Exchange to Lynch versus Clark to State versus Manuel, which was the North Carolina decision that said, look, the rule in the United States from independence on has been the English common law rule. That explanation would be inconsistent.
But Ms. Wong,
yes.
Isn't that explanation, I take Justice Alito's point, and I think he actually makes a good one in the sense that it could be that Justice Gray emphasized domicile to help the public accept the outcome of this case. You're suggesting that the emphasis on domicile was not a part of the rule, meaning he wasn't saying you had to be like a foreigner who is doing everything they can and who can't be naturalized, but he might have emphasized those facts in this case precisely because Chinese immigrants were unwanted, precisely because he had to get this out into the public and people were going to say, whoa, you're saying these people have to, this baby has to be a citizen? And so one could imagine that it was important from a standpoint of helping people accept this citizen rule under these circumstances to emphasize that these particular people in this case were in Justice Alito's first category.
I think that is very possible, Justice Jackson. And as evidence of that, I would point to the fact that if you look at the briefing in Wong Kim Ark, you'll see that even though the parties had stipulated in the district court that Wong Kim Ark's parents were domiciled in the United States, when the case came to the Supreme Court, the government's brief argued that it was impossible for Chinese immigrants to have domicile because they expressed the view that was common among people who opposed immigration by Chinese nationals to the United States. There was a common view that Chinese people were inherently temporary sojourners in the country. And so I do think it's possible, Justice Alito and Justice Jackson, that he was trying to dispel that notion and tell the government.
Absolutely, that at least it reads as though he's trying to calm everyone down. These particular people were domiciled, but we're following the English common law rule. And when you look at the English common law rule, domicile is not a factor.
That's right. I think, you know, who knows why the majority opinion mentioned domicile. We know is a stipulated fact. We know the government tried to renege on that stipulation and rely on this assumption on the part of anti-Chinese advocates at that time that Chinese people couldn't form a domicile in the United States, and he followed the English common law rule.
Ms. Wang, can I move?
Go ahead.
I just wanted to ask you a question about how the exceptions fit within the general rule. You've called them exceptions, and some of the common law sources call them exceptions. So I take that point. But if we think of use solely as tied to the territory, and we look at the exceptions as territorial in a sense, then they seem kind of like natural outgrowths of that rule. And this is what I mean. And this is where I want your help with how the exceptions played out in practice. If you look at Indian reservations as unique places because Indians were quasi-sovereign, separate nations in the American system. If you look at occupied alien territory as territory that's outside the jurisdiction of the United States. And then if you look at the diplomatic exception, almost like diplomats and their children had little bubbles around them, like the embassy is really the territory of that country. And even when they're traveling around, they're all not subject to the jurisdiction by virtue of this territorial fiction. Are those just applications of the rule? And if they are, then what happens to alien enemies like the German spies in Ex parte Quirin, or what happens to Indians who are actually not on the reservation but may be born, say, in Baton Rouge? How does the rule apply in those situations? Does it travel with the person, or is it tied in some sense to the land?
Sure. So let me answer each part in turn. So the thing that all of the exceptions have in common, again, is this sense that the person has this fiction of extraterritoriality around them. Let's set aside the Indian tribal exception for a moment and come back to it. So the example of enemy aliens, for example, ex parte Quirin, is one that is answered by Justice Story in both Inglis and in Rice. And the touchstone under the American application of English common law was that in wartime, the touchstone is whether there's a foreign occupation of US territory. So,
and that's, just to interrupt for 1 second to
Sure.
clarify, and that is territorial. Sometimes it just seemed to me that the rule varied. Sometimes it was stated as enemy alien, and sometimes it was focused on occupied territory.
Sure. So the rule, I don't think there's a separate rule for enemy aliens, and the government's briefs describe the exception as an enemy alien exception. I don't think that is the best way to think about it. Rice and English tell you that when the British forces are occupying Castile, Maine, no one is subject to US jurisdiction there because Britain is governing Castile, Maine. And Justice Story explains, look, if the US then retakes that territory, babies who are born to US citizens by what he called post limine become US citizens. So that's the way to think about any wartime situation, enemy aliens or otherwise. As we heard earlier, Professor Muller's amicus brief tells us how we've thought about enemy aliens in wartime. Even in World War II, when the United States was detaining Japanese nationals who were deemed enemy aliens of the United States, when those enemy aliens had babies in these detention camps, everyone agreed that those babies were US citizens. And Professor Muller goes on to explain that there are many cases of those US citizens going on to a lifetime of government service to the United States. Everyone agrees those babies are US citizens like everyone else. So again, the touchstone for enemy aliens is
So what about Indians? What about the Indian who's off the reservation or born off of a reservation?
Sure. So to start with the basics, I'll refer to the Indian tribal exception just to use the term of art. The Indian tribal exception, Elk versus Wilkins tells us, comes from the constitutionally unique status of Indian tribes. In the Indian Commerce Clause, we know that tribes are treated as basically quasi-sovereign nations. We know that from the Marshall Trilogy of cases. We know from Worcester versus Georgia, where Chief Justice Marshall said that the tribes are essentially a distinct political community.
Well, I understand all that. So just in the interest of time, just to focus you, how I understand why the Indians are treated differently for purposes of the law, but I want to know, is it tied to territory or is it tied to the status of someone as a member of a tribe? Because if you're looking at it because of the special relationship of Indians to the United States as a matter of the Constitution, et cetera, well, I mean, citizens of France are citizens of a different sovereign as well.
Sure. So Elk versus Wilkins doesn't really answer that question. The court says there are two ways to look at this. Either you look at it as the tribal member is like an ambassador, or you can look at it like there's a territoriality issue where people are born on tribal lands, and therefore they're essentially, I think he says, Justice Gray says at one point, we might as well be talking about someone who's born in Mexico.
Well, there's a lot in elk, and some of it's not terribly helpful for you, it seems to me, because Justice Gray, again, strikes again, says that they may be subject to respect to the United States. So there's some jurisdiction. He says they're born in the geographic limits. They are in a geographical sense born in the United States. But because they are not completely subject to the jurisdiction of the United States and owe allegiance distinct from the United States, that's what takes them outside. And that language sure sounds a lot like the Solicitor General's presentation today.
To the contrary, Justice Gorsuch, I embrace that part of Elk versus Wilkins' holding. Justice Gray, of course, wrote both Wong Kim Ark.
I know, and it's a struggle.
Sure. Let me try to help you out with that. You know, the government tries to make it seem as though what sets the exceptions apart, what defines the exceptions, is that the government has some maximum theoretical power. The government could have exercised plenary regulatory power over the tribes, and therefore that's the same situation as a foreign national in the United States. But that's actually not true, because remember, if there's always this background notion, whatever the parameters of the relationship between the United States government and tribal nations at that time of ratification, there was this constitutionally distinct status of the tribes and tribal members, setting them, excluding from apportionment, which was renewed in the 14th Amendment. And that's not true of foreign nationals. If the government were right, that the question is what's the maximum theoretical power the government has, there'd be no ambassador exception, because of course the United States could decide in some instance to go ahead and prosecute an ambassador. There would be inter-sovereign comity considerations there. That's how you define the exceptions. And as Wong Kim Ark says, Elk versus Wilkins has no bearing on the question of foreign nationals.
Ms. Wang, on the earlier answer you gave to Justice Gorsuch on the temporary sojourners cases, those were distinct cases, correct, where the parents had come to the US and didn't want to give citizenship to their kids, took them out immediately, correct?
I'm sorry, Justice Sotomayor, I'm not sure which cases you're referring to.
All right, that we can look at.
Okay.
Ms. Wang, would you agree that the citizenship test in the 14th Amendment is the same as the test in the 1866 Civil Rights Act?
So the words are obviously different. What Wong Kim Ark tells us and what the debates tell us is that the framers, it was the same Congress obviously framing both. Congress was trying to do the same thing with both the 1866 Act and with the 14th Amendment. They wanted to capture the common law exceptions and the Indian tribal exception. They started out with the two separate phrases, not subject to any foreign power, plus excluding Indians not taxed. And as Justice Gray described it in his majority opinion in Wong Kim Ark, they decided to switch to the affirmative phrase, subject to the jurisdiction.
Yeah, well, do they mean the same thing? And wouldn't it be very odd if the citizenship test in the 14th Amendment were broader than the citizenship test in the 1866 Civil Rights Act, particularly in the light of the fact that the 1866 Civil Rights Act was reenacted after the adoption of the 14th Amendment and remained in place until 1940.
Sure, the framers were trying to do the same thing with the language in both.
Okay, so then I think we can turn to the language of the 1866 Civil Rights Act because it's more straightforward. You know, subject to the jurisdiction thereof is like the the puzzle wrapped in an enigma, wrapped in a mystery, but not subject to any foreign power is pretty straightforward. So let me give you these examples. A boy is born here to an Iranian father who has entered the country illegally. That boy is automatically an Iranian national at birth, and he has a duty to provide military service to the Iranian government? Is he not subject to any foreign power?
Not within the meaning of the 1866 Act, Justice Alito. And that's clear from Wong Kim Ark, and it's clear from the debates. What the framers meant by the phrase not subject to any foreign power was referring to the ambassador exception. If it meant what the government contends, basically not a subject of any foreign power, that another country considers you a jus sanguinis citizen, then lawful permanent residents, all foreign nationals.
Well, ordinary public meaning of that would certainly encompass that boy, would it not?
Justice Alito, if you think that the language of the 1866 Act was ambiguous, as Wong Kim Ark says, the shift to the language of the 14th Amendment, which is the operative text, certainly clears up any ambiguity.
What I said about a boy born to an Iranian father is true of born here to parents who are nationals of other countries. To Russian parents, it's true to a child who's born here to Mexican parents. They're automatically citizens or nationals of those countries and have a duty of military service. It sure seems like that. That's that makes be respected, but ought not to control the judgment in a subsequent suit when the very point is presented for a decision. So does that fall within the, what's good for the goose is good for the gander rule? That's how Wong Kim Ark treats what was said in the Slaughterhouse cases. Should we apply that same rule to Wong Kim Ark itself?
Wong Kim Ark tells you what to make of the Slaughterhouse dicta. It was dicta. The issue of citizenship was not at play in Slaughterhouse. And in contrast, the parts of the holding, the parts of the decision that I alluded to are the controlling rule of decision. Again, we look to the English common law in construing the 14th Amendment.
Thank you, Counsel. Justice Thomas, anything further, Justice Alito?
Well, just a couple more questions. So if those who framed and adopted the 14th Amendment had wanted to limit the citizenship test to just those specific groups that you concede fall outside the birthright citizenship rule, why didn't they refer specifically to those groups? Why did they adopt a general rule? They could have said all persons born or naturalized in the United States, excluding Indians not taxed, and those ineligible under common law are citizens of the United States and of the state wherein they reside. Or they could have said all persons born or naturalized in the United States, excluding Indians not taxed, and the children of foreign ambassadors or foreign invaders are citizens of the United States. and of the state wherein they reside. But they didn't do that. They adopted a general rule. So what's the explanation?
I would say the Wong Kim Ark tells us what the explanation is, that the framers of the 14th Amendment, after overriding President Johnson's veto, wanted to adopt a universal rule with a closed set of exceptions. And they believed that subject to the jurisdiction of the United States did that. And that term does describe both the universal general rule and the common law exceptions, with the sole additional American exception for tribal Indians.
Thank you.
Justice Sotomayor?
Ms. Wang, I've not quite understood the Solicitor General's argument that lawful domicile somehow changes the US's dominion over a person or allegiance. Even in Justice Alito's examples, if your parents are Iranian, if you get lawful permanent residency here, that child still, by their laws, when it leaves the United States, must serve in the Iranian army, correct?
Well, I don't know the answer to that. What I can tell you is that under Wong Kim Ark, the court says, we don't care about problems of dual nationality. We don't look to other countries' laws in construing our 14th Amendment.
Well, it was undisputed there that Wong Kim Ark's parents owed loyalties to China, correct?
Sure, yes.
What I'm saying is, even if you become a permanent resident, you're not a US citizen. So
Correct.
Your primary loyalty still remains with your citizenship country, wherever you came from.
That's right, Justice Sotomayor. I take your point now.
You understand what I'm saying? And during temporary, whether it's lawful or unlawful, temporary presence in the United States, you are subject to the US laws, correct?
That's right. The question that the 14th Amendment asks is whether the US-born child is subject to US jurisdiction when they're born.
Meaning, are they within the US territory?
Exactly, other than people covered by that closed set of exceptions.
Okay, thank you.
That's right. In other words, the government's rule, which really is looking at whether someone has a divided allegiance because they're a citizen of another country, would exclude the children of all foreign nationals. And that isn't what they're saying.
Exactly. So the only way that allegiance, lawful or unlawful, has no play in this question.
I would say that the relevance of allegiance is the relevance under the English common law rule that's embodied in the 14th Amendment. All persons born in the territory of the sovereign owe natural allegiance.
Except for the three limited exceptions.
Precisely.
Kagan?
I think I'd like to take you back to the first question that Justice Alito asked General Sauer, and it was this question of, what do we do if we think we have a new problem that didn't exist at the time of the 14th Amendment? I don't think actually that the US government argues the case this way, but let's put the US government's arguments aside and just ask something like, well, everything that you're saying would suggest an answer to the question of people who, the children of people who are temporarily in the US, but here lawfully. Is there any way that there might be a different answer with respect to the children of people who are here unlawfully because of this new problem issue that Justice Alito has raised?
No, there is no difference. And of course, the government's arguments as to people who are unauthorized immigrants in this country all runs through and hinges on their domicile requirement. The first thing I would say in response is that, once again, it's crystal clear from Wong Kim Ark and from the debates that the framers of the 14th Amendment meant to have a universal common law rule of citizenship subject to a closed set of exceptions. And we can't take the current administration's policy considerations into account to try to re-engineer and radically reinterpret the original meaning of the 14th Amendment. The second point I would make is that—
I want you guys to understand that, what's up, everybody? This is Dennis Spurling. Understand that Trump has decided to sit in on these proceedings. So that was a straight shot across the bow of his administration. He's sitting there in the Supreme Court right now. This is the first time we've ever had a sitting president sitting in the Supreme Court during the hearing. So they are also performing. He's eyeballing them, like in the Godfather when Michael Corleone decided to go to the congressional hearings. But let's get back
to come into our country because their children will be citizens. He says, Senator Conness, in your state of California, you will be facing a mass flood of Chinese immigration if we adopt the citizenship rule. And Senator Conness himself, an Irish immigrant, says, yes, and I am voting for that because I believe in citizenship by virtue of birth without regard to parentage. And the third point I would make is a historical one, which is that recall that at the time the framers are thinking about birthright citizenship, there just been 15 or 20 years of unprecedented immigration from Ireland. The Know Nothing Party was dominant in the 1850s, just a decade earlier, and they were vehemently opposed to Irish immigration. They believed Irish Catholic immigrants were unassimilable and could never become Americans. But even the Know Nothing Party members of Congress believed that the children born in the United States to those Irish immigrants were citizens like anyone else. That's the intuition that the framers of the 14th Amendment had. Contrary to the government's arguments now, they wanted to grow this country. They wanted to make sure we had a citizenry to populate the military, to settle the country. And they also had an intuition that was consistent with the founding aversion to inherited rights and disabilities.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
On Lynch v. Clark, which you cite several times in the brief and today, which I appreciate, the government's response is that that decision was questioned at the time and went unmentioned in congressional debates about the 14th Amendment. I just want to get your response to that point on Lynch.
Sure, not true, though the Lynch was not specifically mentioned by name in the 14th Amendment debates. It was a couple months earlier in the debates on the 1866 Act, where Senator Trumbull, Senator Lawrence talks about the great case of Lynch versus Clark, where it was conclusively shown that all children born here are citizens without any regard to the political condition or allegiance of their parents. And then, of course, they discuss the children of temporary sojourn.
Which is, if the 14th Amendment used the phrase not subject to any foreign power, to give a much tougher argument. And then earlier, I think you indicated that that's what they meant, even though they didn't say it. I just want to give you a chance to unpack that, because I think that's
Sure.
If it said that, I think our history would be a little different. And I think the text, even put aside the histories, because that's speculation, the text would be quite a bit different.
Sure. So let me answer in three parts. The first is that Wong Kim Ark tells us that, the court already dealt with this and said, look, the framers were trying to do the same thing with the language of the 1866 Act. To the extent you think that the language is ambiguous or not as good, let's look at the operative text subject to the jurisdiction thereof. The second point I would make is that it's clear from the debates that the framers, in using the phrase not subject to any foreign power, were thinking about ambassadors. And I believe that Senator Wade at one point says, well, I wanted to start with the phrase, all persons born in the United States are US citizens. But then I thought, oh wait, we have these temporary visitors. In fact, the government points to this quote. He says, so there are these temporary visitors we can't make citizens, and we can't make their children citizens. That's ambassadors, and that's very clear from that.
So if that had been the text, your argument would be that was understood to be narrower than its text would read.
Yes.
But that's not the text, so I guess we don't need to deal with that.
Sure, and that brings me to my third point, which is you can't read not subject to any foreign power the way the government urges you to without making the children of all foreign nationals non-citizens. And that's clearly not what the framers were doing.
Justice Alito and Justice Kagan raised an interpretive question that I think is important, which is, are the exceptions, you've used the word closed many times, frozen, or do we reason by analogy to the exceptions that existed based on things that were unforeseen at the time? This comes up in the Second Amendment now, comes up in free speech law. And how do we think about whether it's possible that there could be an additional exception based on modern circumstances, reasoning by analogy to the exceptions that exist? I'm thinking in particular about the non-citizens unlawfully in the country, not the temporary part, but the non-citizens unlawfully in the country.
Sure.
Could you reason by analogy? You've used the phrase several times, I think, the fiction of extraterritoriality. And could that apply? And if not, why not?
Sure. So here, I agree with Professor Whittington, who says that the government's position here is not positing a new application of the rule, but a challenge to the rule itself. And I think that's right. We know that the 14th Amendment's rule does provide for a universal rule with a set of closed exceptions. Wong Kim Ark says so at least twice. It says in an earlier passage that the framers were not trying to introduce any new exceptions. To the contrary, they were trying to foreclose any caste-creating exceptions like the court had created in Dred Scott. The second reason we know this is that the debates themselves had the framers saying, number one, we are declaring what is already the law in this country, at least for white Americans, and we are putting any further exceptions to birthright citizenship outside the reach of any future Congress. They were very concerned about that. That's the whole impetus for the Citizenship Clause. And the third thing I would say is that that it would be contrary to the central purpose of the 14th Amendment Citizenship Clause to admit new exceptions. For all those reasons, the entire history of the Citizenship Clause is driven by the notion that we don't want to have any other exceptions.
And then relatedly, just a separation of powers point, but get your answer. I understand your point about the executive order, but Congress's authority under Section 5 of the 14th Amendment, I guess the answer you just gave means they don't have any authority to look at this, even if they passed it 435-0 in the House and 100-0 in the Senate and said, we're carving out a new, by analogy to the existing categories, a new exception. Your point is, no, they're closed, they're frozen forever.
Correct. And the way I would put it is that the Citizenship Clause of the 14th Amendment, again, has a universal rule with a closed set of exceptions. It sets a floor. So the Congress has, under the Naturalization Clause, the power to expand citizenship to other people not covered by the 14th Amendment, and obviously they have in many ways, but they can't go below that floor that the Constitution sets.
I think Mr. Sauer acknowledged that, and you mentioned this in your opening, that if we agree with you on how to read Wong Kim Ark, then you win. So that could be if we did agree with you on Wong Kim Ark, that could be just a short opinion, right? That says the better reading is Respondent's reading. Government doesn't ask us to overrule, affirmed.
Yes.
That's that. Then last question though, why would we address the constitutional issue? This is the last one. Why would you address the constitutional issue given your argument on the statutory? Our usual practice, as you're well aware, of course, is to resolve things on statutory grounds and not to do a constitutional ground.
Sure. You know, I think we obviously have these two paths to a win here. We're happy to win on either or both of them. I do think it would be prudent for the court to reaffirm its decision in Wong Kim Ark, where it's a landmark decision about the definition of national citizenship in this country. I just think it would be prudent for the court to go ahead and reaffirm that. But of course, we're happy to take a win on any ground.
Thank you.
Thank you.
Justice Jackson? I'm sorry, Justice Barrett.
So I have a question about the exceptions again. So in your interchange with Justice Kavanaugh, just now you were talking about it as a closed set of exceptions. And said that way, it sounds like exceptions that people had in mind at the time of the ratification, but that were not explicit in the amendment. But I took your brief to be arguing that subject to the jurisdiction thereof is the language in the 14th Amendment that refers to those exceptions. Am I right?
That's right.
Okay.
It describes them.
It describes them. And would you say, this goes back to a question that Justice Gorsuch asked General Sauer, our relationship to the Indian tribes is different today than it was at the time that the 14th Amendment was ratified. Let's put aside Section 1401. Is a tribal Indian born on a reservation today on tribal land a natural born citizen under the 14th Amendment?
Under the 14th Amendment, no. Of course, Congress has provided for citizenship for all tribal members in the
By
1924
statute,
Act.
by statute. And so is that because what's subject to the jurisdiction of meant when you say closed set of exceptions, it means that the jurisdiction as it existed at the time of the 14th Amendment is still the jurisdiction today? So let me just be a little bit clear. You know, Justice Kavanaugh asked you if we could create new categories by analogy. So there may be other sorts of people who were present here to whom this subject to the jurisdiction in the same way that we were talking about, you know, the bubbles around ambassadors or the soil of occupied territory or the soil of tribal land. Perhaps those new carve-outs could exist by analogy today, like if the United States carved out some portion of some state and suspended it from its jurisdiction. Wouldn't the principle still apply?
No, Justice Barrett, for two reasons. The first is, again, that there is a closed set.
But why is it closed? The language doesn't say it's closed.
Sure, we know it's closed because Congress's, the very purpose of the Citizenship Clause was to foreclose new exceptions. That's clear from the debates. And I would say that the language describes a closed set as well, because you can't imagine another situation. The government's trying to make us imagine another situation, right? They say, look, what if Congress, in order to do an end run, in order to change the meaning of the 14th Amendment as to unauthorized immigrants' children, Congress can say, we are not going to exercise jurisdiction.
Well, not quite, because it's redefining jurisdiction. It's not quite analogous, right? Because the government's domicile theory is a little bit different than the jus soli theory, right?
Sure, that's right.
Yeah.
I'm just saying that in the second step of their argument as to undocumented immigrants, where they have to get around the fact that undocumented immigrants, by and large, are domiciled in the United States, they're trying to say, look, we're gonna manipulate the law either to define domicile or to carve out, to say, just wave a magic wand and say these babies are not subject to the jurisdiction of the United States. There's still a missing factor under that original meaning of the 14th Amendment, and that's that there is another sovereign who can exercise jurisdiction over this person, even though they're in the United States. And this gets me back to a question you asked Justice Alito. The difference between an ordinary non-ambassador foreign national and everyone who's subject to one of those jurisdictions is that even if you take the government's argument and say a foreign national is subject to their country of nationality's jurisdiction in the United States, is actually not true. If I'm a French national in the United States, France cannot come into the United States, arrest me, and try me for a crime under French law. And that's what sets ordinary foreign nationals apart from ambassadors.
Well, no, I mean, I understand. That wasn't quite the hypothetical. I understand that. Let me just ask you, no, that's okay. Let me just ask you one last question about Indians. So I gather what you're saying is that Congress cannot expand the set of, we'll call them exceptions, right? But you're saying it can't contract them either, and that was the Indian example. So what if, again, putting aside Section 1401, what if our relationship with tribal Indians has changed so much that we would say, no, Indians really are fully subject to the jurisdiction of the United States in the way any other, natural born citizen is? You're saying that that doesn't change the constitutional status of Indian citizenship.
Let me be clear. What I'm saying is that the meaning of the 14th Amendment is we have to go with the original public meaning. And obviously at the very time that the framers were, thinking about the 14th Amendment, at the time of ratification, that relationship between the United States and tribal nations was in flux, right? The government has made various arguments about Congress's authority, but the way the framers thought about it and the way that Wong Kim Ark describes it is that there was a unique constitutional status, unlike any other relationship between sovereigns in all the world, between the United States and the Indian tribes. And that is what gave rise to the pre-existing exclusion of Indian tribal members from US citizenship, and that's what the 14th Amendment captures.
Justice Jackson?
So I want to understand how you are responding to the government's argument that because temporary visitors and undocumented immigrants are still governed by their home countries, and in the government's take on this, you can't have you can have allegiance to two different sovereigns. Those groups can't have the requisite allegiance to be subject to the United States for the purpose of the 14th Amendment. That's what I hear the government saying. But I do think that that seems to rest on a different understanding of allegiance than what was in the English common law. And that when we understand what the English common law thought about allegiance, you can see that you can have allegiance to two different sovereigns at the same time. This kind of goes back to Justice Alito's questions. I mean, I was thinking about this, and I think there are various sources that say this, that you obviously have permanent allegiance based on being born in whatever country you're from. That's what everybody recognizes. But you also have local allegiance when you are on the soil of this other sovereign. And I was thinking, I, a US citizen, am visiting Japan. And what it means is that, if I steal someone's wallet in Japan, the Japanese authorities can arrest me and prosecute me. It's allegiance, meaning can they control you as a matter of law? I can also rely on them if my wallet is stolen to, under Japanese law, go and prosecute the person who has stolen it. So there's this relationship based on, even though I'm a temporary traveler, I'm just on vacation in Japan, I'm still locally owing allegiance in that sense. Is that the right way to think about it? And if so, doesn't that explain why both temporary residents and undocumented people would have that kind of quote unquote allegiance just by virtue of being in the United States?
That's absolutely right, Justice Jackson. And that comports with the plain text of the 14th Amendment as it applies to everyone born in the United States, other than those subject to the exceptions that were baked in a close set. You owe natural allegiance as a US born citizen. If you want to look at the parents of those people, and let's say the parents are foreign nationals but not ambassadors, the parents owe temporary allegiance.
Right, so the
under
babies
English
get
common
the
law.
permanent allegiance piece of this, and the parents get the local allegiance piece of this. So to the extent we're looking for allegiance, we have it.
That's right.
Thank you.
Thank you, counsel. Rebuttal, General Sauer?
Thank you, Mr. Chief Justice. Justice Kavanaugh, turning to Lynch against Clark that you raised didn't come up when I was talking about it. Keep in mind that we say that was questioned at the time. It's questioned by a higher court in the same state, the state of New York, in the Ludlam decision in 1860, specifically said that someone who's traveling or sojourning abroad, though born in a foreign country, is not born in foreign allegiance. So obviously there's tension within that very state, and that's what contemporary commentators noted. And I make a more fundamental point about that. Lynch is not interpreting the 14th Amendment because it predates it. So it's not looking at the language of the 14th Amendment. It's looking at, what does the word citizen mean, for example, in the clause. So there's an anachronism to their reliance on it. And I think that turns to a point that Justice Alito emphasized. Once you get to that language of the 1866 Civil Rights Act, where Congress said not subject to any foreign power, Clearly, we are no longer dealing with the British conception of allegiance because Calvin's case and Blackstone say whether you're subject to another foreign power is irrelevant to whether or not you become a citizen. So again, the concession that I heard to be made that those two mean the same thing, which this court held in General Building Contractors, that the Civil Rights Act has the same scope as the Citizenship Clause of the 14th Amendment. Once you're saying not subject to any foreign power, Congress has clearly departed from the common law, the British conception of allegiance, that monarchical conception of allegiance. They have adopted the Republican conception of allegiance. And there's all kinds of evidence going back to late 1700s that that's the way they thought about it. And there was a reference, I think, in my friend's presentation about the Marshall Woodworth treatise from the late 1890s. That treatise also, just like Lynch against Tark, the language they quote is actually describing the case or the law, the status of the law before the adoption of the 14th Amendment. So, but if you actually look at the treatises we cite again, I mean, Wharton, Morse, Justice Samuel Miller of this court, Lesser, Black, Hall, Winchester, Taylor, Westlake, Ballot, there's this consensus going from the time of the 14th Amendment onward, when they're looking at the specific question of temporarily present individuals in the jurisdiction, all those sources say their children are not citizens. And that goes both before and after Wong Kim Ark. You see a similar consensus actually in the congressional debates, where whenever it comes up, temporary sojourners, it's understood, the context indicates it's clearly understood that those children are not citizens. And I would therefore finish where I began with drawing a stark contrast and turn back to the first question that Justice Thomas acted. That Republican Congress in 1866 had a very, very clear understanding that the children of the newly freed slaves have the requisite allegiance to the United States. This was all about overruling the grave injustice of Dred Scott and making sure that allegiance was granted to the children of slaves. However, you have this contrast of a very, very strong, impressive consensus, both in the original understanding, in the congressional debates, and carrying over into commentators for 50 years afterwards, that the children of temporary sojourners are not covered. And for those reasons, we ask the court to reverse.
Thank you, counsel. General, the case is submitted.
All right. Welcome, everybody. Welcome to the broadcast. I hope everybody is still with me. I know that was a lot to follow. But I'm going to take the time now to try to break down the issues that we heard. I want to first thank everybody for waiting this time period. I know it's, interesting, right? It's interesting. Let me make sure you guys are still here. And if you have any questions, feel free to put them in the super chat, and I will answer as many questions about what you heard as possible. I'll do my very best. But what I want to do, and hopefully in my recap of what just happened, I can kind of summarize some of the issues beforehand, because I want you guys to be, this is probably the most consequential ruling of our time period. Okay, this is right up there with Dred Scott. It's there with Brown versus the Board of Education. This is literally going to affect probably tens of millions of American citizens. This is how consequential this ruling is. Now, again, my name is Dennis Spurling, and as I always say to everybody, thank you for joining me. I know we got you had 2 hours of Supreme Court argument. Some things you probably noticed, the attorneys referred to themselves as friends. I can guarantee you they are probably not friends. Just to kind of lay the background, most people know this, but the Supreme Court is located in Washington, D.C., and the President of the United States, the only president who has ever attended a Supreme Court hearing, did so today. That is President Donald Trump, and I suspect he went there to eyeball these folks and let them know, look, I put a bunch of y'all up there. Okay, so y'all better do what I say do. And this whole thing stems from an executive order that Donald Trump signed, I believe, like his first week in office, saying that he wants to enforce birthright citizenship. Shout out to Mr. Leeward. He wants to decline or make sure that people who are born in this country of illegal aliens their children don't have citizenship. And so he basically signed an executive order directing all of the branches of government to under his authority to do that. Now, again, let's just kind of recap, and I want to give a big shout out to everybody in the chat room. Thank you guys so much. Also, big shout out to all my MVPs, the people who contributed to the super chat. I will read everything you guys say towards the end of the broadcast. And I thought it was very important to get this one out. You know, I think this is very important on this first day of April. Well, you know, for posterity, let's just kind of recap. So today, the Supreme Court, as you heard, of the United States heard one of the most consequential constitutional cases of our lifetime. And it's a case that goes to the core of what it means to be an American. At issue is whether the executive branch has the authority to redefine birthright citizenship. It's a principle that we all understand to be rooted in the 14th Amendment, and it provides that all persons born or naturalized in the United States and subject to the jurisdiction thereof, okay? And that's the key phrase, subject to the jurisdiction thereof, are citizens or thereof are citizens. Most people understand the born or naturalized part, but the question here hinges on what does the jurisdiction thereof actually mean? And so this morning's case, commonly referred to as Trump versus Barbara, arises from an executive order that seeks to deny citizenship to children born on U.S. soil if their parents are not citizens or lawful permanent residents. In other words, we're going to put an end to anchor babying. Somebody type anchor babies in the chat room. This is what the Trump administration is saying. We're going to put an end to this right now. And see, that order has already been blocked by lower courts as unconstitutional. But today, the Supreme Court was asked to decide whether more than a century of settled law will stand or be fundamentally interpreted. Now, inside the courtroom today, the federal government advanced very specific arguments. That phrase, subject to the jurisdiction of, does not apply universally. And that children born to undocumented immigrants or temporary visitors, you know, they have a term called birth tourism, where people are literally coming to this country to drop babies off, and I'll talk about that a little bit, and then they go back to their country. But either way, he's saying those temporary visitors, their children don't automatically qualify for citizenship. Shout out to my man, Essential Entities. Now, the government framed birthright citizenship as a modern distortion, arguing that it creates incentives for unlawful immigration and birth tourism. But almost immediately, the justices began pressing that the argument, you know, several members of the court, including Chief Justice Roberts, expressed skepticism, the question of whether the government's interpretation will be squared with long-standing court cases, particularly the Supreme Court's 1898 decision, United States v. Wong Kim Ark. Now, I want you all to understand what's going on in 1898. We are a very racist country. I think I've gone a long way to explain it. And not only did we have blacks, okay, for all you whites, I want all the white folk who white supremacists and white nationalists. See, you would still have a white country if you didn't come and invade a country full of people who are already here, and they weren't white, Native Americans, you call them. You would have had a white country if you didn't turn around and bring black people over here to do your work for free. You would have your own country if you decided to build your own railroads instead of bringing all the Asians over here, but you didn't, okay? And that's kind of what happened, all right? So bottom line is, these folk at that time in 1998, it was still very nationalist, it was very racist, it was post-Civil War. You had the country still angry. Even the people who fought to free the slaves had racist tendencies. So in 1898, Chinese people were persona non grata. They didn't like them. They brought them over here to work them to death and get them out of here. Okay, they were at no point were to be citizens. They would just come here to work, be exploited for pennies on the dollar. Sometimes they weren't paid. But bottom line is, that's the climate of 1898. Now, on the other side, you have the civil rights advocates, and I believe that lady that you heard, that attorney, was for the ACLU. They argued that the Constitution text, the history, and the purpose are clear, that the 14th Amendment was designed to establish a broad, inclusive rule of citizenship, not a narrow conditional one. Now, here's the thing, family, and I'm notoriously known for speaking the cold, hard truth. What is this really about? Okay, what is this really about? And I listened to this broadcast from the Supreme Court, and I know you all were listening too, and I didn't hear Black American much. I heard slave. They kind of snuck that in. I think I might have heard them mention in that 2 hours of legal jargon, and I heard Black people mentioned maybe 3 times, basically. I didn't hear a lot of that. I mean, because, but what is this really about? And I'm going to say it plainly. And of course, they don't want to bring that up because that's an ugly part of history that they don't want to talk about. But we're going to talk about it on this page. And that's why y'all keep coming back. Y'all keep coming back to talk to me, because I'm going to be honest with you. Now, what we're watching right now is not just about an immigration debate. It's not just about policy. And it's definitely not about politics or just politics. It's about who benefits from rights that were paid for by Black people's blood and labor and sacrifice. Okay, it was the sacrifice of Black Americans who brought this forth. See, for over a century, foundational Black Americans, whether you want to call it the American Negro, if you are, what do you all want me to refer to us today? Would you like to be the American Negro? Would you like to be freedmen? Would you like to be the Solon people? We can be FBA today, whatever you want to be. I'm talking about that group of people who can trace their heritage to a time before this country was even a country. I'm talking about the people who can trace their heritage to a time when there was chattel slavery, and a vast majority of us, 90 to 90% of us were enslaved people. This is who I'm talking about. For you all who are offended at FBA, oh, you FBAs is a cult, you a cult. Look, we could be Negroes again. Would y'all like to be colored? We can be colored if you want to be colored again. I like the term foundational Black American because I've been a Black American my whole life, and putting foundational as a qualifying adjective in front of that helps further delineate as to who I am and my heritage, so there's no confusion, because you can technically be a Black American and be from, I don't know, pick a country, Ghana, the Caribbean. If you're an American and you're classified as Black, then you're a Black American. No different than if you're white and you're in America, you're a white American, but you can truthfully be from South Africa and have citizenship in the United States. Nevertheless, let's not get caught up on that, because the point of what I'm saying today is that for over a century, foundational Black Americans, the American Negro, we fought through slavery, Reconstruction, Jim Crow, civil rights movements, and we forced the United States of America to live up to its own Constitution. And every protection we're talking about today, whether we're talking about equal protection, civil rights enforcement, anti-discrimination laws, it came at a cost. And that cost was paid by us. And when I say us, I'm not talking about every American. I'm not talking about Black American. I'm talking about them little old colored folk from down south in the Midwest who grew up through slavery time, who worked from could see to can't see every day. Okay? Those little old Black folk that chopped their words up and couldn't speak standard English and couldn't read and were tortured and maligned and berated and treated like second-class citizens. That's what I'm talking about. Those people, those colored people, those American Negroes, those freedmen. Those are the people I'm talking about. Okay. All right, those descendants of indenture, of chattel slavery, who were captured and sold by Africans and brought to the United States, who were shipped back and forth like cattle throughout the Caribbean and back up to the United States and back there. That's who I'm talking about, okay? The price was paid by us. Now, here's the uncomfortable truth people don't want to say out loud. Many of the legal gains that came out of that struggle of our people have been expanded in ways that allow others, and when I say others, I'm talking about non-American Negroes. I'm talking about non-FBA. I'm talking about non-ADOS. I'm talking about non-freedom. Even if you're Black, those things that we fought for, that we died for, have allowed others to benefit, even when those protections were originally designed to address specific harm of slavery and its aftermath. And that's the tension. That's what this is really about. When people talk about affirmative action, for example, even the Supreme Court acknowledged in cases like Students of Fair Admissions versus Harvard, which was brought by a bunch of Asian students, that those programs were not for them. They were there for Black people. They were there to remedy historical discrimination, okay? But that has shifted over time into a broader diversity framework that includes groups who were never part of the original constitutional injury, which includes white women, you know? And see, that's not an opinion. That's what the court wrestled with. See, you see the same tension in immigration and birthright citizenship, and the modern interpretation is largely shaped by that case that you heard mentioned, United States versus Wong of 1898. And that's been understood to grant citizenship to nearly anybody born in the US. But of course, the critics argue that over time, that interpretation has moved far beyond the original purpose of the 14th Amendment, which was to overturn Dred Scott and to secure citizenship for Black people who were formerly enslaved, because you had Black people in the United States and they were citizens. Not every Black person in the United States, even before it was considered a country on its own, not everybody was a slave. You had Black people who were citizens, but the Black people who were enslaved were considered property. They were classified as property. You had Black people who were citizens. You had Black people who were classified as property. They had no rights. They had no right to vote. They had nothing. And so what do you do with them if the law still says you're classified as property and the Civil War hasn't been fought? The Dred Scott decision pops up and say, this is not a free Black person that we have. This is a Black person who was a slave, who escaped slavery. And now this court is before us, but he's classified under the law as property. So he has no right that a white man or anybody has to adhere to. He's not a citizen. So how can he petition the court for his freedom, even though he's here? So officially, it sent us back years. And so that Dred Scott decision was horrible, okay? Now, take birth tourism. I want to talk about this, and this is why this is heating up, okay? You got federal prosecutions in California, and they've exposed networks where foreign nationals, particularly Chinese, have paid tens of thousands of dollars to come to the United States late in their pregnancy. You 7 months pregnant, they have hotels set up in different parts of California where Chinese come, and they basically hang out in these hotels. And they, at the point where they get pregnant, they go to a hospital, they have that baby, and now that child they give birth to has now secured U.S. citizenship for their children. And in 2019, the federal authorities charge operators of these schemes. Okay, they charge operators of these schemes with crimes. In some of these businesses, they coach the clients on how to evade immigration officials. And reports have also documented hundreds of companies. I mean, there's 500 known companies in China that target the U.S. for birth tourism. Okay, they openly advertise it. They monitor the Chinese. Programming, internet, whatever, and there's 500 companies that do this, right? And they're openly advertising the benefits of having an American passport for their children and for future economic and educational advantage. And whether you agree with the framing or not, that's not hypothetical. That's what's happening. You can Google that. So the question people are asking, the question that Americans are asking is simple. Has birthright citizenship become disconnected from its original purpose? And that was to what? Give citizenship to Black people. Has something that was meant to correct one of the greatest injustices in American history, and that is chattel slavery of Black people, has it turned into a system that has been strategically used by our enemies in ways that the framers of the 14th Amendment never contemplated and would probably consider an evil? And that's the real issue sitting in front of the country right now. And this is where the federal government comes in. Under Trump, there's been no push, there's been a push to re-examine this entire framework to ask whether the current interpretation of the 14th Amendment reflects what was actually intended or whether it is expanded beyond constitutional limits. That's what's being challenged, and that's what's being tested. So don't let anybody reduce this as a simple pro-immigrant versus anti-immigrant argument. That's not what this is. This is a constitutional question about the original purpose versus expanded interpretation. It's about historical justice versus modern application, and ultimately it's about who the Constitution was written to protect and how far these protections are going to be extended. And I'm telling you right now, this issue is not going anywhere, because once people start questioning whether the constitutional protections are being used in ways they've never intended, that conversation doesn't stop. Now, let me explain something to you. I want to get down in with you. I want to talk to the Black people. And I want to get down to a level, the people don't want to go. I'm going to go there. Because see, beneath all of this legal language, all of this constitutional theory, all of these political talking, it comes down to something real. And I think, for generations, Black Americans, first of all, we're not immigrants. We didn't come here by choice. We didn't enter through a system, right? We were here before the system even recognized us as human beings. And from that position, we fought on battlefields, in courtrooms, in streets for rights that did not exist when the country was founded. We fought in every war that this country ever had. Every war, we've shed blood in every war. Your ancestors, Black people. Every war. We've paid the right to be citizens by blood. Hell, we fought for the 14th Amendment. We fought for the 13th Amendment, the 14th Amendment, and the 15th Amendment, and the Civil Rights Bill, and the Voting Rights Act. We had to fight for things that everybody else was given when they showed up. And see, those weren't abstract victories. Those were structural changes to the Constitution itself. And so now the question being raised is this: when those rights expand beyond their original purpose, who controls that expansion? Because what many people are seeing is a system where policies that were originally tied to correcting a specific historical harm done against Black Americans has broadened into a general benefit for anybody that shows up. And that's far beyond the original context. Let's look at affirmative action. Where even the courts have recognized that those programs were supposed to help Black people who were former slaves, who were undereducated, who were banned from reading. And now they've evolved into something called, DEI, a broader diversity framework, and you don't even see any Black people in that. You even have immigration policy. What does giving slaves citizenship have to do with immigrants coming to this country? I want you to understand that. You see? They're basing enforcement decisions and border policy that directly affects the labor market, which Black people participate in, our wages, our access to opportunity. And it's affecting it in a negative way, especially working class Americans. The truth is, family, I'm probably going to be all right. I did some early sacrificing early on. I built my business up. I'm a highly trained, experienced attorney. I'm going to be all right. But what about the brother out there trying to support a family as a blue collar laborer? What does he do? What about all the plumbers and the electricians and the roofers who are being put out of business because you got people coming from other countries who will work for little or nothing? You can't support your family. Hell, what about the teenager who wants to be an entrepreneur and cut grass during the summertime to save up for some school clothes, and he can't do it because the Hispanic workers are coming in cutting everybody's grass for $20. He can't compete with that. Him and his little lawnmower and his 10-speed. So again, you see it, you see what's happening. It directly affects us. And you see it most clearly in birthright citizenship, where the argument no longer is just about protection, it's about the scope. Now let's be honest about something. This isn't about rejecting anybody. Okay, I'm not rejecting other people. I'm saying I'm prioritizing my people. I'm prioritizing the American Negro, the foundational Black American. I'm prioritizing them colored folk that came before me, who are the shoulders I stand upon. See, this is about what is my priority. You understand? And for each foundational Black American, you have to be on your side right now. And your side is foundational Black American side. Right now, we can be friends with people, but at the end of the day, when it comes to politics, power, money, you have to know how to align yourself with the group your group, because otherwise everybody else is there. It's like you having a family discussion with another family and half of your family is on the side of the other family. And now you look like an idiot. Shout out to Willis Addison. You understand what I'm saying? We can have internal conversations later, but right now we have to be on each other's sides. And that's anybody who is against our interests. We have to treat them accordingly. That doesn't mean you have to hate anybody. That doesn't have to be, you don't have to be racist, but you have to point out that at this particular time, things are changing. Money and resources are being redistributed. Power is being allotted. There's a changing demographic and other people are vying for the #1 spot. And more likely than not, Black Americans will never be the #1 spot in numbers, but we do need to try to maintain some power and some political authority because they're trying to replace us. Look, every nation on earth defines who belongs and how, and every country sets rules around citizenship and immigration and national identity. That's not controversial. That is sovereignty. And so when Black Americans raise concerns about how these rules are being applied in the United States, what we're really asking is, where is the line? Who decides it? And does history matter in this decision? Because these people who come to this country, they don't care about white American history. They don't care about Black American history. All they see is fertile land and opportunity, and they will exploit it. And so if citizenship becomes purely automatic and disconnected from any concept of allegiance or national connection, then it changes how the system functions. Did you see what those Somalis did up there in Minnesota? Do you think they're aligned with the United States? Do you think Ilhan Omar, do you think that $26 million that she just got from being in office for the past, but you think she's gonna spend that on foundational Black Americans? Do you think she's gonna spend it on any Americans? She probably wants them to deport her right now. She can take that money and get on out of here. But anyway, what happens now is all of these decisions affect access to public resources, which means parks, it means housings, it means school, it means representation, it means long-term policy decisions that will affect us. And for many of us, and I'm talking about Black Americans, us colored folk, us Negro, us foundational Black Americans, ADO, Solon people, the concern is that the same government that delayed justice for generations is now rapidly expanding benefits in ways that don't account for that history. So understand clearly, the position you're hearing is not simply opposition. It's a demand for clarity of what's really going on. It's a demand that the Constitution be interpreted with an attention to its original purpose, which benefits us as foundational Black Americans. Now, a demand that policy decisions reflect historical reality is not just a present day convenience. A demand that the question of citizenship be treated with seriousness is deserved. And because that at the end of the day, this isn't just about immigration, it's about ownership. It's about the constitutional origin story, who wrote it, who fought for it, who expanded it, and now who gets to define what it means. And until that question is answered in a way that people believe is fair, this debate is not going anywhere. We don't think it's fair what's happening. Okay? Now, what's happening systematic is you got a bunch of new arrivals. They're being concentrated. This is why black people are mad. So a lot of people are like, how can these black people be aligned with what these white supremacists are talking about? These white nationalists. Nick Fuentes has a large black following. Why do you think that is? That young man who got shot, he has a large black following. Why do you think that? Trump has a significant, he got more votes than any other Republican president in recent history. Why do you think that is? Largely because black people are angry. If I go to Chicago right now, I bet I could throw a rock and hit a black Republican. You couldn't do this under the Obama administration. And the reason is because those new arrivals are being concentrated in the very same black neighborhoods where resources are already stretched to the breaking point and communities have been underinvested for decades. I remember as a young man growing up in Los Angeles, and I remember when the Hispanics began to come up from El Salvador. And at first it was just a novelty. It was a couple of them in a room. They would put them in one side of the room and they'd have their own little Spanish speaker. It didn't bother me. And now here we are 40 years later, and they've taken over Los Angeles. The black population has decreased by half, and they ran us up out of there. What do you think is going to happen when all these other people start coming in, the Chinese and the Asians and the Arabs and all these folks start coming in? Harlem is being regentrified. And it's not, we always put regentrification, we put the face of, we make white people or white Americans the face of regentrification, and that's not it. You understand? There was a time when Miami was a black town. Black people built Miami. These days, you can barely find a black person in Miami. Same thing in Los Angeles. But see, these neighborhoods are being stretched and at a breaking point. We've had black communities underinvested for decades. This is not an area where they have excess housing and excess jobs or excess public services. Shout out to Big J. These are places where people have been fighting just to get a foothold. Where rent is already high and relative to the income, and schools are already overcrowded, and access to stable work is already limited. And then without any serious plan to expand capacity, we add more people who don't speak the language, who don't understand the culture, who are sometimes openly hostile to us. I go a long way in explaining to you the anti-black rhetoric and racism that comes from these countries, whether we're talking about Latin countries, Asian countries, Muslim countries, African countries, Caribbean countries. I talk about the anti-Black American rhetoric that comes from these people. And you flood them and you dump them in our communities. And this is why black people are upset. And so you have, what this does is it creates immediate real world tension and pressure. More people competing for the same apartments. It drives the rent up and availability down, and more applicants for the same entry level jobs put downward pressure on the wages and the stability of families. And it puts more strain on medical facilities, clinics, schools, local services. It means longer waits and thinner support for everyone. And none of that is theoretical. It's basic supply and demand playing out in black communities that were already on the edge. And here's the part people don't want to say out loud. When policy increases competition without increasing supply, the people who already were absorbing the cost, okay, they're the ones dealing with the tighter housing markets, more volatile work, fewer pathways to move up. And when the pressure builds, it doesn't feel like abstract policy. It feels like an opportunity it's harder to reach. You wonder, the American dream is not dead. It's just so hard to reach if you don't make at least $250,000 a year. You understand? If you're going to increase the population in a specific community, then you have to increase the capacity at the same time, more housing, more infrastructure, more job pipelines, more investment. If you don't, you're creating competition without support, and that's a recipe for disaster. So who's deciding to put these people in our community? I think many of you would agree largely it's a lot to have to do with the Democrat Party. They're tired of dealing with black people. They are tired of our demands, are tired of us asking for tangibles. They can't count on us. The only reason they've tolerated us for the past 60 years is because they got our vote for free. It's no different than them tolerating our presidents in these United States because we work for free. And the minute we stop working for free, we were persona non grata. I want you to think about that. See, if we're going to be serious about fairness, then policy can't just move people. It has to move resources with them. Otherwise, what you end up with is exactly where we are right now, trying to stop the influx of all these people and shut it down at its core. And so this is why black people feel that way. Now, I'm going to take the opportunity to kind of go into a little detail about some of the cases that were discussed. I've talked a little bit about Dred Scott because, you can't understand the 14th Amendment. You can't understand birthright citizenship. And you definitely cannot understand what's being argued at the Supreme Court unless you understand Dred Scott. Now, this is where it starts. So let's go back to 1857. Okay, the Civil War started in 1861, more or less. There was a buildup for about 20 years. So we had 1857. Dred Scott, you got a man, he was an enslaved black man who'd been taken by his owner to a free territory, okay, where slavery was not allowed. So Mr. Scott does what any reasonable person would do. He said, he goes to court and say, if I live on free land, I'm free. That's the argument. Simple, logic, fair. But the Supreme Court, in one of the worst decisions in American history, said, nope, that's not going to happen. And they didn't just say not just no. They went further than that. The court held that Dred Scott was not a citizen. And more importantly, that black people, not just enslaved black people, because up until that point, black people had rights. I've gone and I've discussed with you the fact that we were judges, we owned land. This is before the country was even a country. We were high-ranking military officials. You see, this is what we had before. But the Dred Scott decision, okay, it said that black people, whether they were enslaved or free, whether their family had been here since before the country was founded and it was landowners, they could not be citizens of the United States at all. This is what they said. We couldn't even be citizens. This is what the Dred Scott ruling said. So imagine it's 1857. Your family has been here since, I don't know, 1501. You've owned land in Virginia. You've owned land in Maryland. You're a black person. You've been here. You one of those black folks who've been up for free. This is 300 years almost. And now you got this Dred Scott decision to say not only are the slaves not citizens, but the free black people who hold positions and have degrees are not even free. So that set us back 100 years. And I've often commented on this. When I read the literature about the people who brought this case, many would say, don't bring this case. This Supreme Court is not the one. Don't bring this case now. Dred Scott, drop it. Don't bring it. We'll find another way to get you citizenship. Don't bring it. We'll buy you freedom. Leave this case alone. And they pushed too hard and too fast. You had a bunch of Southerners on the Supreme Court at the time and say, this is just not the time. So strategically, it was not a good time to do that. Okay. But let me say this again so you understand the weight of it. The Supreme Court said at that time regarding Dred Scott, black people had no rights that white people were bound to respect. This is 1857, okay? No rights all across the country. You understand? And that's not an exaggeration. That's what the court said. And now we're not just talking about one man losing his case. We're talking about the Supreme Court of the United States declaring that an entire group of people who had been in this country for generations were outside the Constitution altogether. No citizenship, no standing in court, which means you can't sue. They can run you off your property. They can, ladies, you had no autonomy to your body. You had no rights. So if a white man did something to you, horrible, right? If a white man did something to you horrible, you couldn't even prosecute him criminally. Black man, what that means at that time period, after Dred Scott, a white man could literally go to your house, take your wife, your daughter, and do whatever he wanted to do with her. There's nothing you can do about it under the law, unless you decide to take the law in your own hands. Same thing with property. He could just come up and take your mule. He could just come up and take your horse. He could take your land. This is what they did. And you couldn't sue about it. That's what the Dred Scott decision did. And it gets worse. The court also said that Congress did not have the power to ban slavery in federal territories. That means even in places that were supposed to be free, slavery could still exist. So if you were one of the lucky ones who escaped to Maryland, I don't know, New York, somewhere like that, you got free, they couldn't even ban slavery there. So what you have here is a decision to strip Black people of any claim to citizenship or the right that goes with it. It expands slavery instead of limiting it, and it deepened the division that ultimately led to the Civil War. So things got worse. So that happened in 1857, and the war popped off 4 years later because they're like, nah. And guess how many? 200,000 Black men showed up to fight the war. And see, this again, that's the time period we were living in at the time. And this case didn't just reflect the tensions of the country, it poured gasoline on it. And so now here's why this matters for everything we're talking about today. After the Civil War, the country had to fix this. They're like, all right, we fought a war. Look, okay, and the thing y'all need to understand, Black people were fighting for their freedom at that time. Lincoln often referred to it as the Florida problem. What had happened, you had a bunch of Black folk who had ran down to Florida. The United States government spent $20 million trying to fight those Indians in Florida. That would be the equivalent to $600 million today. All right, Black people were fighting, they were cutting up. You think this was not easy, okay? Keeping Black, we were gonna be free, or y'all wasn't gonna have peace. That's pretty much what Black people had determined. We were gonna be free, or you all weren't gonna have peace. There was a uprising, a documented uprising where white people got unalived for every year during slavery. Okay, it was ugly. Period. Hell yeah, they're doing the Negroes are doing this now. They've taken over South Carolina. You see? So it wasn't pretty. And so after the Civil War, they said, okay, we can't have that happen again. We can't have another Civil War. And so they had to correct what the Supreme Court had done. And that's where the 14th Amendment comes in, okay? So the Supreme Court ruling, and just a little bit to understand about how case law works. Case law just interprets the law. The law is created by Congress. So Congress said we need to make a law, and we need to emphatically state what the law is going to be. And that's where the 14th Amendment came from. And that's the Citizenship Clause. That says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. You see how that fits in? You can no longer say these Black people who were born here in the United States can't get treated like citizens because of the color of their skin. No, if they were born here, they're going to get treated like full-blooded citizens. That's it. Now, what does that have to do with immigration? I want somebody, what does that have? Does that even remotely sound like it meant the framers intended for people who just came up here from Eagle Pass and had a child, their children are supposed to have citizenship? Do you think that that's what that means? Not at all. Not at all. And see, that language was written specifically to overturn Dred Scott. That's not up for debate. It was designed to say we're never going, it costs too much in blood and treasure. We're never doing that again. We're never going to deny citizenship to a group of people who were born here. okay? Specifically black people, because now you got black women getting raped, you got black men having their property stolen, they're mad, they're rioting everywhere. You see, we got to get this, we can't keep taking citizenship from these people, they're gonna tear it up, they're here already. So when you hear arguments today about birthright citizenship, you need to understand this isn't happening in a vacuum. This is directly tied to Dred Scott, because one side is saying the 14th Amendment created a broad universal rule. If you're born here, you're a citizen. And the other side is saying, no, it didn't. That amendment was written to fix a specific historical wrong, slavery, and the products thereof. That specifically Dred Scott, you got these racist people on the Supreme Court back then who said that not only are they not citizens, they don't even have any rights. We had to correct that because that caused too much trouble in our democracy. Okay, it was about securing citizenship for black people, for descendants of slaves, that American Negro, that colored person, that freedman at the time. What we call now foundational black Americans. Not creating a universal rule for everybody in the world. And that's the tension, that's the fight. Now let me give you a real takeaway. See, Dred Scott represents what happens when the Supreme Court excludes people from the Constitution. And that 14th Amendment represents the attempt to correct that exclusion. So the question we're dealing with today is, when the court interprets the 14th Amendment, are they preserving the correction or are they defining it? Because if you get that wrong, if you misunderstand what Dred Scott was, why the 14th Amendment exists, you risk repeating the same constitutional mistake. And that's what we see happening. Now, another thing I want to kind of break down is this, okay? So now we talked about Dred Scott. I want to go into a little bit more detail about the 14th Amendment. Are you all enjoying this? I hope I'm not boring you. Am I boring you? Let me know. If I'm boring you, I'm sure I can find something interesting to discuss. I'm sure there's somebody dating someone. Would you all like to talk about Michael B. Jordan and the text message he sent to his ex-girlfriend? Is that what you all want to talk? I can talk about that. I can be messy. I can give y'all some relationship advice. You want some relationship advice? I can do all that. If this is boring, we can make it interesting. I might get 100,000 subscribers before the end of the day. Speaking of which, if you hadn't hit that doggone like button, you committing blasphemy. And if you haven't subscribed to the channel by this time, if after all this talking that I'm doing, you hadn't subscribed to the channel right now, you are a horrible person. I'm gonna say that right now, horrible. You have me here working in the middle of the day. I done left my job to come talk to you all. Make sure you subscribe to the channel. Make sure you subscribe to the channel. Let's get the subscriptions up. I'm only a couple thousand away from 100,000. I'm gonna have that plaque on the wall real quick, man. You guys make sure you subscribe to the channel. Go ahead and subscribe. Let me see what my subscriptions are. We're taking a little quick mini break so I can get you all to subscribe to the channel. Okay, don't play me. I've been telling y'all for weeks, don't play me. Why would y'all do me like that? I'm about to get me some AARP. That's another thing. I just found out I'm eligible for AARP. I don't know exactly what AARP, but I was told I can get some discounts on some tires and oil changes and such. Okay. But before that, I need y'all to AARP that subscribe button. Y'all make sure you subscribe to the channel right now. I'm trying to check and see what my subscriptions are. Hold on a minute. Let me find out. Take the time and subscribe to the channel. Don't play with me. I got 9. Oh man, I'm almost there. I need about another 175 people and I'll be at 97,000. Why don't y'all take the time and subscribe to the channel? Keep Uncle D happy. Somebody type Uncle D happy in the chat. Ain't I happy? Look at me. I'm a happy person. You guys make sure you subscribe and give me another 175 subscriptions. That's all I need you all to do. Okay. Y'all my know-it-alls. That's what I'm gonna start calling you, my know-it-alls. You come to this page, you're gonna learn a lot. You're getting some high-level conversations over here, and I try to break it down so people can understand it. Because if you listen to enough lawyers, they speak in a whole nother language. So I try to speak to you all in a language that regular folk can understand, and I try to make it relatable. but I respect your intelligence. That's why I speak on a high level about complicated subject, but I try to do so in a way that it's easy to understand because I try to make it personable. And I think that's why my channel has been growing significantly over the past few months or so, you know, because I realize there's a hunger out there for knowledge. There's a hunger out there for understanding. People really want to know. But unfortunately, we have the knowledge, the information is locked away in the minds of people who are too busy to talk to you. And the only way you can get it, you will get a chance to speak to them is if you attend one of these expensive universities. And so what I try to do is basically, this is some university level classes, and I spend a lot of time preparing them. And I hope you all are learning something, and I do it in a way that you actually able to walk away with something. So some of you all know more about the Dred Scott decision than many lawyers, because they don't necessarily teach this in this detail in those constitutional law classes. Just this conversation, you know more about the Dred Scott decision than most lawyers do. They don't even test for it on the bar examination typically. So, well, anyway, we're going to carry on. And again, as I always say, if you learn something, I should earn something. I'm not begging, I'm not asking for anything, but it is a way to show me that those people who learn, that's the way I can gauge how well I've done on that particular day. Because, you know, if the days I get a lot of donations, and when I say a lot, that's like 20, 25, 30. I mean, I got 50 ones. That's amazing. Especially for a middle-aged man with a sport coat on, you know, that's pretty good that I'm able to get all these folks in here and listen to what basically is history. I'm teaching law and history on my page, and I have all these followers. That's amazing. But anyway, let's get back to work. So again, I took the time to break down the Dred Scott decision. Shout out to Digital Nomad. I want to talk to you about the actual content of the 14th Amendment, because this is what this is about. All right, let me break this down for you in a way that actually makes sense. And I don't want to speak over your head. So the core argument in this is that citizenship, the citizenship clause of the 14th Amendment, was put in place for a very specific reason. And that reason was to secure citizenship of the descendants of enslaved people, what many refer to as today as foundational Black Americans. Now, what that means is that this wasn't written as some broad, open-ended rule to give automatic citizenship to anybody born on U.S. soil, no matter the circumstances that they got here. Okay, that's the modern interpretation, but this argument is and here's the thing. That's not what it was really about. Okay, we need to understand that the amendment through history and lineage is not just about geography. Now let's talk about the key language, because everything turns on this phrase: subject to the jurisdiction thereof. And see, that's what a real fight is. And so all that you've heard over the past 2 hours, 3 hours is reference to that one phrase, subject to the jurisdiction thereof. And that argument being made here is that the phrase is not universal. It doesn't apply to everybody automatically. Instead, it applies to people who owe full allegiance, political allegiance to the United States. Shout out to Sir Yellow. Shout out, thank you for the membership. People who are part of the national community that existed after the Civil War. So under that interpretation, you have folk who are not citizens, who are undocumented, who are the only here temporarily, or who snuck up through some, overstayed their visas, student visas, came up through Eagle Pass. Their children are not fully subject to the U.S. jurisdiction in the constitutional sense. That's the argument that they're making. And that's the one that they want to go with. And if that's true, then being born in the U.S. alone is not enough. And that's the shift, because that's been the doctrine that we've been following for 100 years. And see, this argument is saying citizenship is not just about location. It's about legal belonging and political connection. It's not just about you were born here. It's you're a part of this nation in a constitutional sense. That moves us away from the pure just sole or just soil argument into something deeper, something tied to history and relationship. Now, let's go to the historical piece because this is critical. Look, again, the 14th Amendment was passed in 1868. And it was designed or passed to overturn Dred Scott v. Sanford, which I discussed came about in 1857, about 9 years before. And of course, there was an intervening civil war that happened. And the 14th Amendment, it guaranteed citizenship to freed slaves and their descendants, our babies, as Donald Trump so eloquently states. And that's not debatable. That's a historical fact. So the argument here is that the amendment was remedial. It was fixing a very specific injustice. Shout out to my 2 cents. It wasn't designed to be a blanket rule for the entire world to show up at our border and drop a baby off. And that's not what it was about. Okay? And so now it leads into the idea of lineage-based citizenship, or as we call it, foundational citizenship, or as the white folk have been calling it lately. What do they call it? They call themselves heritage Americans. Basically, this argument is saying, look at the descendants of enslaved people who built this country, who fought in every war, who fought for their constitutional rights, and were the intended beneficiaries of this amendment. So that's what it says. Look at it. This is what this is meant. And so the claim to citizenship is not the same as someone who came here through, they went to Newark airport, they overstayed their visa, and they've been hanging out in New York. This is not who this is. You had a baby. That's not who this is for. It's not even close. One is rooted in the foundation of the country. The other is based on policy. And that's what this is fundamentally about. And that's the distinction being drawn. So now we get to divide between what the document calls foundational citizens and immigrants. Foundational Black Americans are defined as people whose ancestry traces back to slavery and before, who had to endure Reconstruction and the early American history that we went through. And our citizenship is described as inherent. That's a powerful word. It's not, it's inherent, meaning it's built into the structure of the Constitution. It's not something granted later. We're not naturalized citizens. And that's why when Black Americans tell you our ethos is in this country, we were born here. We are a people of the United States. There's no other people on this planet like us. We were literally bred here from many races and many people and many cultures, which includes African and European and Native American, et cetera, and Asian. This is who we are. No wonder they call us colored. We was definitely colored. We wasn't one color or another. We were multiple colored. I get why they call us colored, but I don't want to talk about that. But now flip the script. Okay, on the other hand, you got immigrants and their kids, and they're described as people who entered through the modern system. Okay, and they still have ties with another country. Just because a person came to the United States through Eagle Pass and they're from China, they're still a citizen of China. They can go back. They still have ties there. They can still vote in those elections. They still, as one of the justices said, a child born or a person in Iran who comes to the United States still has an obligation to serve in the Iranian military. Right? So they still have real ties to those countries. They just came here through the modern immigration system, as broken as it is, but they still have obligations to where they came from. Their presence here is viewed as conditional, and it's based on laws and policies, not constitutional foundation. So from the perspective, from that perspective, the argument is simple. You don't automatically get constitutional citizenship just by being born here in the United States if you don't meet that deeper standard of allegiance and belonging. Now, I'm going to be real with you. That language in the document is quite aggressive, okay? But if you strip that away, the legal argument underneath is this: the current interpretation of birthright citizenship has been expanded and exploited and manipulated beyond what was the original intended. Can we all agree on that? Okay, a black man and a black woman who had a black child during slavery and after slavery, giving those people citizenship has nothing to do with a child a woman who came up here from Guatemala or who came here from China, stayed in a hotel in California after being having entered the country at 7 months of pregnant and gave birth to that baby. Why are those two people equal? Why do both of them have citizenship? And we're basically saying, and what Donald Trump and the general, the attorney, it wasn't the attorney, it was the Solicitor General who was the attorney for the president. And for you all who don't know, the Honorable Thurgood Marshall was also the Solicitor General for the president. It's different from the Attorney General. The Solicitor General is generally the president's lawyer who advocates on his behalf as related to governmental issues. But the bottom line is that's what the Solicitor General, this has nothing to do with that. This is for black people. They didn't mention us that much, but that's what it was for. But what happens now is because of this expanded interpretation, it creates incentives tied to childbirth. It stretches that Constitution further than the framers of that amendment ever meant for it to go. That's his argument. In other words, it takes something designed to protect black people and turns it into a universal immigration rule. How do we even get there? And of course, you know, once you have a child here, you can apply for different citizenship visas, and you can stay here and watch your little American child until Donald Trump came around. Now, they mentioned also, basically call that an anchor baby. Now, they also mentioned the United States v. Wong Ark, okay? In that case basically said if you're born here, you're a citizen, even if your parents are foreign nationals. And in that particular case, I want you to pay very close attention. The parents were foreign nationals, but they were here legally. They had permission to be here, or they weren't here illegally. What this argument was about today was getting rid of people who are here illegally, okay, and who are not subject to the jurisdiction thereof of this country. Okay, now here's the thing: either that case has been misunderstood, because this is what the argument, or has been applied in a way too broadly over the time, and the claim is that the court expanded that meaning, the 14th Amendment, beyond its original scope. Now, underneath all of this is a bigger constitutional philosophy, originalism, right, which we like sometimes as black people. Today, you like it. Yeah, we want y'all to follow the original. Black people, I want you to come to the originalism. Yeah, we're originalists. Yeah, we want you to follow the original interpretation of the Constitution. Well, did you all know that the original interpretation of the Constitution said we were 3/5 of a person? Do we really want originalism? Do we really want to go back to that? Probably not. Okay, but for this particular instance, we want originalism. Y'all some hypocrites, but hey, it is what it is. Now, the thing is, again, and I guess I should explain what originalism really means. That means you interpret the Constitution based on what the people who wrote it intended. Those white men with the wigs on back in the early 1776, and the historical context they were dealing with, right? They had no planes, cell phones, just a lot of mosquitoes and malaria. Not what we want it to be today. Okay, what it actually meant when it was written. That's originalism. And it also introduces the idea of membership-based citizenship. And that citizenship is not just, a legal label. It's tied to shared history, shared struggle and national identity. And there's a concern here that the courts and the policymakers have expanded these constitutional rights, which were intended for black people, beyond their proper limits. Now, to be fair, this isn't, look, there's counter arguments. Some people are saying if you start limiting birthright citizenship, you open the door to the government to overreach. You heard what that government said? You heard what that ACLU lawyer said? She said, look, if you all allow Donald Trump's executive order to stand, the next thing's going to happen, he's going to start to denaturalize people. He's going to say, hey, look, your mother came over here and had a child, and that was fraudulent because this was birthright tourism, and we're going to denaturalize you. So you have kids in California, you have kids from all over the world in California and all these other states that were born here to parents who were here illegally. And now they're saying, and now we know how Trump is. We know what Trump is. We're going to denaturalize them. We're going to get them out of here. We're going to denaturalize them and send them back to the country of their parents' origin and let those, they're going to go back to China. They're going to go back to Brazil. They're going to go back to Nigeria. They're going to get out of here. They're going to go back to Haiti. We're going to get them out of here. That's what he's saying. And that's what she's saying. And then the judge said, but then the lawyer solicitor general came and said, no, we'll let them grandfather in. We're not going to send the people who are here. In other words, we don't expect you to denaturalize children who were born here before you issue this ruling. But anybody born after this ruling, you know, when you go to the hospital, if you can't prove citizenship, sorry, you're not a citizen until you can otherwise do so. And so she's basically saying that would be a big mess. And then the solicitor general said, no, we won't do that. We won't start sending kids home. He's on my kid's 3rd grade baseball team. We won't send people home. Let me tell you something. If they put a hotline up and say, look, call in all the anchor babies, we giving $300 a baby, you all would be at the nursery hanging out. Here's one now. I need the 3. When am I going to get my check? You can cash app me my check, because we know how people are. All right. And so that's why she's saying, so that was that fancy language. If you start limiting birthright citizenship, you open the door to government overreach. Government overreach means really bad things. You could end up in a situation where you have U.S. citizens who are being targeted. And other people argue that the 14th Amendment was written broadly on purpose to prevent exclusion and to avoid creating second-class groups of people. You heard what the lady said. She said the Congress can't even do anything with that. They were purposely limited. There's only a few exceptions, and that's it. You can't expand it anymore, because if you can expand citizenship, then you can decrease it. That's kind of what it sounded like they were saying. But, you know, again, the real debate is that if this argument were actually adopted, the consequences are going to be massive. Birthright citizenship would no longer apply to everyone born in the United States. Instead, citizenship could depend on your parental status, your allegiance, your possible allegiance, right? And it could end up with a whole new category of people born here but not recognized as citizens, right? So we get a 3rd-class citizenship, another group of people that we can exploit as capitalists. And to me, this is what it gets down to. You don't have to go, but you're not a citizen. You can't go to college. You can't go to school for free. So you got to work. So now we got another labor class. You see? I mean, I'm just saying, I've seen it happen before. I told you guys on another broadcast when white people change the rules on you. Black Americans know that very well. White people will change the rule on you, and a lot of immigrants, they don't need you anymore. And a lot of immigrants are finding that out. And this is something that we've always known as Black, but that's why we say, let's get our own stuff. We're going to have our own neighborhoods, our own churches. We're going to have our own schools, we'll have our own system of worship. We have our own clubs, because white people will change the rules on you. You were legal, lawful one day, invited up here, and the next day you're illegal. Okay? And these are the conversations that Black Americans have when we sit around the coffee table. You know, we sit at we've learned these things. And unfortunately, a lot of immigrants are now having to come to the realization that you all should have listened to us, but you didn't. And now your whole life may be turned upside down. So I don't know, you know. I don't know. I don't know what's going to happen. I will say this, there's a deeper constitutional question, and that's where this case becomes more than immigration policy. You know, it asks a fundamental question. Can the executive branch, can Donald Trump or any future president, by order alone, redefine a constitutional guarantee that has been settled for over a century, 125 years? Because if that answer is yes, then citizenship itself becomes subject to a political reinterpretation. If Donald Trump can swing this far to the right extreme, then what's going to happen when you get Gavin Newsom? I know you all are going to vote for Gavin Newsom. I know all of y'all, you might not like him, but you're going to vote for Gavin Newsom. You got to get away from Trump. I know my black people. You're going to vote for, he's a nice white man. He can go all the way to the right, okay? All the way to the left. But the bottom line is, if the answer is yes, then citizenship itself becomes subject to political reinterpretation. But what if we say no? And the court reaffirms the constitutional rights are not negotiable based on policy preference or political pressure. What happens then? Now, instead of having 1 million new anchor babies coming from China, now you got 10 million. So what happens to the United States in 10, 15, 20 years? What happens? Where do we go from here? What does America look like in 50 years if you have all these people who are foreigners, who have allegiances to different countries? And I mean, you know, it's one thing to deal with white folk. It's another thing to deal with people from everywhere who speak different languages, different foods. I mean, we won't be playing baseball anymore. We're going to be playing soccer. They're going to make us call it football. I don't think it'd be pretty for black people, you know? You know, we've been dealing with racism of white folks for centuries now, but there's other kinds of racism that can be imported. And there's also the intra-racism that we see burgeoning in the African and Caribbean communities directed towards Black American people. And it wasn't prevalent as it is now. Before, it was just whispers. We don't like them, stay away from them. But now they comprise about 25% of what is considered the Black American population in the United States. They got bold. They're speaking with their chest. They telling you everything they don't like about Black people these days, Black Americans. So what is it going to be like in 50 years when the Black American population is 40% and the foreign-born or second, third generation population is, you know, 60%? What happens? What happens to our culture? You see what they did with Essence Fest. It gets co-opted, it gets turned into something else. All the Martin Luther King birthdays are going to be changed. I mean, all the historically Black colleges, all of the holidays that we celebrate, what happens to us? And nobody's they don't want to hear what we have to say now. And so, you know, that's the extreme. If we allow things to continue happening the way we are. And I know it's distasteful for a lot of Black people to be aligned with outright, overt, white nationalist, racist rhetoric. And that's why it's distasteful to say, hey, I voted for Trump. Shout out to Kevin Lott, because we know they're racist. I mean, if you don't believe Trump is racist, I mean, the racist thinks he's a racist, okay? You don't think the people in his cabinet are bigoted and prejudiced towards Black people and everybody else? I mean, you know, they're finding reasons to get Black people out of the military, which has traditionally been a gateway to the middle class for us. I mean, I'm just saying. But, you know, as they say, you know, politics makes strange bedfellows. So you have the most you have the group of people in this country who fought racism tooth and nail for centuries, now having to force themselves, at least the ones with good sense, having to align themselves with the most racist modern day presidency that I've known of, even far more so than Reagan. And this is about survival, you know, and this is where we are. This is why you got Black people who become Republican. This is why you have people like Nicki Minaj, who can read the tea leaves. And she herself is an immigrant. You have that young man who used to be on the comedian Nick Cannon. I supported Trump. You have Chili from TLC, because they see the writing on the wall. They see the polls. And despite all these Black people saying, hey, yeah, I voted for Trump. I mean, I voted for Democrat and Republicans are bad. There's a secret cohort of Black people who won't tell you that they actually support what they see going on right now. They won't tell you. It's like you're around a bunch of Baptists and you secretly a Pentecostal and you can't say anything. You know what I'm talking about? You can't really, you eat there eating the sandwich. All right, praise God, you know. You can't do it. You can't bring it up, because if you start telling a bunch of Baptists you're Pentecostal, they're gonna break the Bible out on you, and the little church fans. Okay. So many of you harbor these feelings. I know. I'm trying to tell you. So a lot of the things that used to be, when foundational Black Americans or the colored people, the American Negro were the dominant group of Black people, all that is going to change. All you Pan-Africans out there, I'm telling you, I can see the tea leaves. You are becoming persona non grata as far as the majority of foundational Black Americans are concerned. Most Black Americans don't have passports. Most Black Americans, they like the idea that there's a continent like Africa with a bunch of Black people in it, but now that they realize that these Black people are openly hostile to us, and in fact, it looks like they're trying to make a play on our reparations that we've been fighting for hundreds of years. Oh, hell no. Somebody type, oh, hell no, in the chat room. So you even see that whole romanticizing African, that Pan-African thing, that's going out the window. You're going to become persona non grata. If you're not 100% all the way down with the fight that we have right now as Black people, and that is maintaining our identity and making sure these people don't come push us out and take our resources here in the United States, then you're going to be unliked. You're going to be like the LAP. This is like when I was young. You had Black people who were members of the LAPD. They got treated worse than the weed salesman back in LA. You a LAPD punk. That's, I'm just keeping 100 with you. You're persona non grata at this point. So, but for years, hundreds of years, it's like, yeah, brother, this ain't it. It's hard to catch a Black. It's going to be hard to catch Black folk running around with the African medallions on their shirt in 10 or 15 years, because foundational Black Americans, because we're politically at odds. You see, and that doesn't mean you don't have friends you love who are African and Caribbean and Asian and Latino. That's not what I'm saying. I'm just saying that when it comes to politics and finance and what's going on right now, we are at odds with each other and we're trying to save ourselves. So things are changing. But again, let's do some hypotheticals. So if the court strikes down Trump's executive order, and this is the most legally consistent outcome based on precedent, the court could reaffirm the case that I talked about, Wong Kim Ark. It would hold that the 14th Amendment guarantees birthright citizenship broadly, and it would limit executive power in constitutional interpretation. This would preserve the current system as is, and it would shut down the door, and at least for now, attempts to restrict birthright citizenship through executive action, that would cease. It'll be up. So everything, if they strike it down, if they strike down Trump's executive order that he signed in 2025 in January when he first got into office, case is over. Everything remains the same. As soon as we get another Democrat in, they can open up the floodgates. Eagle Pass will be open again. The ICE agents will be sent back home. And everything will go, it'll be how it is now. We're just going to be flooded over the next couple of decades with illegal immigrants having children. And the America that you see now, 50 years from now, is not going to be that. All right. Now, here's the other thing. Let's talk about a different possibility. The court upholds the executive order. This is less likely, but it's possible. All right. If the court accepts the government's argument, it would redefine jurisdiction in a narrower way. And it could exclude children of illegal or undocumented or people who are here temporary. You and that girl, you dating that girl, you know what I'm saying? You over there. You got that girl at NYU. She's here you got her pregnant. She's here on a student visa. You better be an American, because she can't convey a citizenship to that child. If you're not an American, she can't do it. Shout out to Myron Magnus. Okay? So that's going to fund every child down in you come to the doctors, I need to have the baby. Where you from? Where your papers? Where is your husband from here? I don't know who the daddy is. Well, you're not an American. The baby's not going to be an American either. All right. So now you got a bunch of children born in the country who have no nation. You understand? And that impact would be massive, potentially affecting hundreds of thousands of children every year. You got hundreds of thousands of children born every year with no nation. They don't have social security numbers. They're just just a problem. Shout out My 2 Cents Revised. This is what it would do. Okay. It creates a new legal class of individuals born in the United States, but not recognized as citizens. Okay. That's what that would do. It would be, I mean, and to me, whew, it would be something to see. Okay. If you talk about anarchy, imagine a bunch of kids that don't have social security numbers, that can't work. The only thing they can do is underground work. You're gonna have a bunch of kids who I mean, disenfranchised, passport kings. You talk about disenfranchised, nothing to lose, nowhere to go, no country to go to. Can you imagine that? That's what Trump is trying to do right now. Now, would it benefit us? I believe so. In the first, and you know, because we rich now. Black people are the richest group of Africans on the planet. I mean, let me tell you something like this, man. Only 4% of families in the United States make more than $200,000 a year. And, you know, you think everybody's rich, but they're not. But considering the fact that most families make less than $200,000 a year, the fact that we as Black Americans we predominantly live in the states that are doing the best, Georgia, Texas, Florida, North Carolina, basically the South, these are where people are coming to because these are the states where there's the biggest, most robust economies. Yeah, of course you have California, it's an outlier, but you got so many people leaving. We're around the money. This is where we got the best land in the United States, as far as I'm concerned, the best weather. We're doing well, okay? So we are actually part of the more elite class. I know, right? We always talk about how poor we are, and you know, we have 1.7 million millionaires. 6% of Black families make more than $100,000 a year. We're doing pretty good, okay? I'm just saying, we're doing pretty good. And so we'll probably benefit from this. You have somebody else to cut your grass and, you know, free labor. You understand what I mean? So we're going to participate in the exploitation of that third class of citizenship with no rights. And that's just how capitalism works, whether you like it or not. But I guess I'll deal with that another day. But again, you're going to have hundreds of thousands of people born every year with deficient legal status, but not recognized as citizens. They can't vote. There's nothing they can do. All right. Now, what if the court splits the difference? And I think this may be something that might happen. Okay. This is where it gets interesting. They avoid the full constitutional question. They rule on procedural grounds like an injunction power or scope of relief, or they narrow the case without fully redefining what citizenship is. That would just delay the ultimate decision, but keep the issue alive for future litigation so it doesn't go away. Okay, they could kick the can down the road and say, well, this is something Congress needs to deal with. All right, they could cop out like that, but my thing is, why would you even take the case up if you didn't want to deal with it? You understand? So those are the three things I think are going to happen. I don't know. I couldn't tell you. I will just have to see. But what I want to do at this time is I want to take the opportunity to read the super chats. And if you have learned something, then I should earn something. I want to thank everybody who's contributed to the super chat, the Cash App, or the PayPal. I'll start off with reading the PayPals first. I'm not PayPal, Cash Apps first. I don't think I got a PayPal at all. Did you all subscribe to the channel? I need more you all. I need 160 people to subscribe to the channel before I finish reading these super chats and Cash App. Don't play me. I'm not here for the games. Okay? I'm not here to play with you all. Y'all gonna subscribe to my channel and stop playing with me. Shout out to Joanne Perry Woods. Thank you, baby. You got all them names too. Well done, Dennis, on the break. Thank you so much. I appreciate you. Who else do we have in here? I think I have some more. Can't seem to see. Okay. All right. Also, Patricia Hightower. Thank you so much, Patricia. I appreciate you for the two people who contribute to the Cash App. Remember, if you learn something, I should earn something. Other than that, you don't owe me a dime, baby. You don't owe me nothing. Nothing, nothing, nothing. I would like you to like my I would like you to like my channel and subscribe. I appreciate that. But I'm gonna keep on working either way. Okay. You guys make sure you take the time to look through all my old videos too while I discuss this thoroughly leading up to this. Now we're gonna take the opportunity to just thank the people who contributed to the Cash App and the Super Chat, or should I say the Super Chat now. We got 23 Super Chat. Sign the petition. Your leadership is needed. Man, have you all checked out my petition? I hope you all check out my petition where I say, hey, we need to sue these Africans over here trying to get our reparations money, you know? And the thing is, the best defense is a good offense. They can't get reparations from the United States, which American taxpayers would have to pay. If we say, no, you all are responsible, we're gonna sue you. You see what I just did? Many of you all don't realize that. But my whole thing was saying, you know what, let's put them on the defense, because I knew it was coming. Many of you all were so upset with me. How dare he sue Africa? This is only a couple years ago, right? You are so upset with me when I said, hey, we need to sue Africa. We need to put them back on their heels. Y'all was so angry, but now you understand, don't you? You see what the president of Ghana tried to do? Huh? You guys remember that? I was going to come out of retirement and talk about that. I'm like, no, I'm going to let them sit with it. I've seen so many people try to address the subject. I can't believe that. They're saying that the American government said that the Ghanaians participated in slavery. Yeah, that's what I was saying. But y'all didn't believe me. Y'all had to wait till the white man told you. You didn't believe on Uncle D. I've countered every argument, and I'm talking about somebody please put the link to my petition. I believe we have 10,000, and it asks Donald Trump to sign an executive order, which would look into the legal sale of Africans who were transported here after 1808, when slavery became illegal. Okay, because see, remember, before that, slavery was legal, and part of the argument that the United States put forth is, hey, how are you going to punish us for something that was legal at the time, especially considering that you all participated in it? Okay, so please, somebody put my link to the petition in the chat room. I mean, I should probably do it myself. Doggone it, I don't want to get too distracted from this thing. I want to kind of wrap this up and get y'all out of here. But somebody, please, one of my some of the people with the wrenches, put that link in the chat room real quick so everybody can see it. I'll make sure I put it below this broadcast, and you all look in the description section, and I will have the link for you all. If we get another 1,000 subscribers, easy. All you got to do is click on the button, and you can. It's not a lot of work, and we'll have 10,000 subscribers. I need about another 1,000 people. That's pretty good for 2 or 3 weeks. But thank you so much, LTD 2672. I appreciate you for that. Also, Passport King, he said, thank you so much for streaming this historic case. Let me see here. He says that directly applies to the right of U.S. FBAs. Also, your commentary is always appreciated. Thank you so much. I appreciate you. And Mr. CMA Allsource, who came through very early on in the broadcast. Incredible work. Keep adding massive value and driving the paradigm shift our country needs. Yes, thank you so much. But I know, look, I might not have 100,000 followers, but I know I see a lot of people using my same talking points that I've been talking about for years. Y'all thought Uncle D was just a mean man. I've had people, you so mean, you racist. You might not even, you know, I had one dude tell me I was too ugly to have beautiful women. I was handsome when I was young. What you mean? I was handsome. I didn't have all this fuzz on my face. They just said I must have been ugly. What y'all were mean to me because I just tell you the truth. That's all I'm doing. That's so cold. Y'all some cold-blooded people out there, man. This is why this is why you shouldn't go to comedy clubs with black people. If you sensitive, they will hurt your feelings, man. I'm just giving y'all the truth, man. But anyway, let's get back to the work. Let's see who else we got. So shout out to you, Mrs. CMO All Source. I appreciate you, family. Willis Addison, we appreciate your steadfast discipline for FBA. Yeah, man. Thank you so much. Now, the truth is, I'm an advocate for black men. And I think the delineation is good for black men. Okay. Now, I have always been an advocate for black men. That's what I came in doing, and that's what I'm doing now. And when I say black men, I'm talking specifically about black American men. Uplifting and protecting black men means that there are more black men who feel that they have a voice in the black community in America, which means they'll continue to invest in the community. What any woman will tell you, any woman with sense and experience will tell you, as long as a man is talking to you, he's still interested. As long as he cares to hear your complaints, as long as he's engaging with you, you're all right. It's the minute he stops talking to you. I want ladies, and this is I'm gonna go there. I'm not giving any relationship advice because Uncle D doesn't do relationship advice. But I want you to understand, as long as black men are willing to talk to black American women, black American men, as long as we can have a conversation, we can make it. It's when the brothers stop talking. And so I believe that being an advocate for black men and me speaking and telling everybody, this is how black men feel, this is their position, this has been part of my legacy. Now, a lot of people didn't like the things I was saying, but you see what's happening now. It's the truth. Here I am 6 years later, and everything I've been saying is true. You don't have to like what I'm saying, but it's true. And I've helped keep the conversation going with statistics and the truth and all that stuff. I don't go that deep into relationships, but I tell you what, this is what the government is trying to do to you. They're trying to get rid of you. They're trying to put you in jail. They're trying to undermine you. They're trying to everything. This is what they've been trying to do. And so I've been keeping the conversation going. Now, unfortunately, because we have all these other people attacking us, we can't talk about our interpersonal relationships right now when we got Asians and Hispanics and Africans and the federal government all trying to crack down on black people. In the middle of these anti-immigration raids, folk decided to try to pivot and come and talk about black fatigue. You understand what I'm saying? I mean, you all are running these Hispanics up out of here and y'all want to, well, let's go after the blacks. So it always lets you know who the real target is. And so understanding that, I said, no, it's time for me to go ahead and continue advocating on behalf of black men specifically, but I'm gonna get these people up off us with the truth. And I'm gonna hit them with this history. We're not going to let them cause our differences in our discussions to be distracted from the fact of who the real adversary is. Black men and black women have been talking to each other in this country for centuries, and we have not always necessarily saw eye to eye, but that's the nature of man and woman anyway. But what we're not going to do is let outsiders come in and destroy us. I don't care what color they are. And that's why we have to do what we have to do. We got to filter out these people whose allegiances are not with the survival of black American people, foundational black American. We got to sort them out. And that's the importance of delineation. I think delineation is good for black men, and whatever is good for black men is going to be good for the black community, because you can have a community of women, but if you don't have the men there to protect and build and bring resources to the community, it won't exist. And that's why I'm at. It's real simple logic. Why do I support black foundational black American men? Because I am one. Why do I support foundational black American causes? Because those are the people that raised me. That's my lineage. It makes sense, doesn't it? Why would a black man, I mean, think about it. I'm a black man, but I don't support the interests of foundational black American men. That's stupid. And then one thing I'm not, I ain't stupid. I might chop my words up. I might got this bad hairline that hiked up like that, but I ain't stupid. I know plenty, and I've seen plenty. And I know those who stand with their own and their own side in a war survive. And those who get divided, right, they get unalived. All right. And it just so happens that because of this position that I'm taking, and this strong position and this consistent position, that you have so many other people who are saying, yeah, that dude is that I like that. And y'all can take my talking points. I don't care. I'm not one of those people. And one of the most powerful things that I put in motion is this petition and this information about how Africans sold Black people into slavery. Now, when I start talking about it 6 years ago, when y'all can look at my broadcast from 4 or 5 years ago, I was in the Dominican Republic. I did like I think I did an 8-hour broadcast that I linked together. And I said, look at the history of what these Africans did. They participated. Nobody liked me. Everybody was angry with me. But here we are. Here we are now, 6 years later. We got a petition. And, I might not get there with you, as they say, but the petition, the information is out there. I put it out there. All you have to do is reparations from African nations and look at the executive order. It's all there for the future minds to look at. But this is how you keep these wolves, okay? This is how you keep these wolves from coming into in the gate. You say, y'all trying to take money away from Black American cause. Y'all think you would get a dime. If the Ghanaians got millions of dollars in reparations, do you think any of that would come back to the United States? First of all, who's going to pay for it? The American taxpayers. Who are American taxpayers? Black people. So we're going to pay reparations to Ghana for slavery that happened in the United States against Black people? America, that's what you want? Now, if you're stupid enough to follow, just think about that. We're enslaved over here as Black American and taxpayers. We got to pay reparations to people in Ghana for slavery. On top of that, the ones that sold us over here. Woo-wee. They must think you boo-boo the fool. Anyway, I got off subject. I ain't been here in a while, so I got a lot to say. But anyway, let's go on to Lee Ward. Thank you for the super sticker. Essential entities, the work that you've been doing, man. Man of God is phenomenal. Salute to you, sir. Thank you so much, brother. I appreciate you. Who else we got in here? That's one of my people that's been here for a minute too. Essential entities. The Desmond Lavelle. Thank you. So keep working. I'm gonna keep working, brother. Appreciate you. And Willis Addison. Thank you too. Unpack it, Esquire. We appreciate your insight. Good looking out. Crew, I can't say that. Ray, I'm gonna call you Ray. Thank you, Ray. Appreciate you. And Big J. Salute to you, Uncle D. Breaking this down. That's why I find these tethers highly disrespectful, because they only care about citizenship and taking resources, not the blood, not the sweat, not the tears of our ancestors. It'd be one thing if they was real appreciative and y'all wasn't saying these bad things about Black Americans. Are easy people to get along with. It's really about boundaries and respect. And see, the thing is, we respond. You always say, oh, Black Americans are so violent, because we check people for getting out of line with us. That's why. If you go to the cookout and you good and you chilling, you probably be all right. You go to the comedy club and you good and you chilling and you not disrespecting anybody, you probably gonna be all right. But in this country, and I don't want to get too far off wrapping this thing up, but we were disrespected so long. We are hypersensitive about disrespect. We enforce boundaries even with family members, because we know once you let them start breaking your boundaries and disrespecting you, everybody will do that. And whether we're talking about the slave plantation or being in the hood or whatever, this is part of our culture. You're going to respect us, because not forcing people to respect your boundaries in this hostile anti-Black country could lead to you getting wiped out. See, we often talk about the peace movements and the civil rights movement and the non-violent protests. We don't talk about them brothers who had them guns. You can come over here if you want to. The deacons of defense. We don't talk about that very often. Them country brothers who came out of World War I, who said, look here, let me tell you, in the Korean War, like, you white folk can play with us if you want to. We're going to put a bullet in you. See, there's plenty of that out there. There's a book out called Negroes with Guns. And see, that was really the unspoken backbone of why the peaceful civil rights movement worked, because they know, hey, we got to do something with these darks. We got to do something with these colored people. They're Americans too. They got guns too. Yeah, so I want you to understand that. That's why we're heavy on respect. So if all the immigrants had come over here and respected us and not tried to treat us like N-words, we wouldn't be where we are right now. But it's been 60 years. Y'all been coming over here since 1965, when we fought to undo the racist immigration system, which prohibited Black and Asian and everybody else that was non-white from coming here. If you had been a lot more respectful, we wouldn't be where we are right now. But you poked the bear. We are the only people on this planet who has fought against white folk and won on many levels and forced them to do what's right. Black Americans did it. You all had your own countries and couldn't do it. Colonialism came out, and you only had 50 years of colonialism, and y'all still suffering from it. We have 400 years of chattel slavery, second, third class citizenship, and we are richer than all of y'all right now, more educated than every other group of Black people on the planet. This is how tough we are. This is who we are as a people. And so why would you make enemies out of us? How could you dare disrespect Black people when you reap the benefit from the umbrella of success that we created? That's what I'm saying. But anyway, thank you, Big J. Let's finish these. I'm long-winded today. I got to get out of here. Learning, thank you so much, Kathy Smith, 3181. Thank you, baby. I appreciate you. Who else we got? Digital Nomad. Did you learn something today? Act like it. That's right, brother. Appreciate you. Sir Yella, 638. Thank you for the membership. Thank you for the membership again. Also, DC WO20905. Thank you for the membership, family. I appreciate you. My 2 cents. He says, subject to thereof, isn't a minor under the age of 18, subject to a parent's citizenship status. Exceptions would be to abandoned child found in which no knows the parent. Okay, brother, I don't know exactly what you're asking, but subject to a parent typically is the child. The child typically has the parent's citizenship. Now, under the current immigration law, if the child is born in the United States, the child also has American citizenship. So in effect, that child could be dual citizenship or potentially a dual citizen. That's kind of how that works. All right, we got 25 super chats, man. If we can get 30, that'd be plenty, but we'll see. But only if you learn something. Thank you so much, Kevin Lott. Thank you for your service. FBA, I appreciate you, family. Myron Magnus, thank you for the dedication. Yes, sir. Appreciate you. My 2 cents revised. Wong Kim Ark parents was barred from U.S. citizenship because of the status intent of arrival into the USA as a merchant modern day business visa, unless they would have changed intent later, in which they didn't. They went home. They actually went back to China. So that's a good observation. SCOTUS ruling for Trump 7.2 minimum. Just what? Man, we'll see. I don't know. Passport King 7.7. We'll see what happens. Who else we got in here? The child Wong Kim Ark subject to the parent status until the age of majority 18 because of the principles of just solely. The child at 18 can choose its citizenship at the least. Do you know up until I think it was 1976, if a woman wasn't at least 21 years old, she could not convey citizenship to her child. So in other words, let's go back to Barack Obama. At the time he was born, his mother was too young to convey citizenship to him. And correct me if I'm wrong. Please beat me up in the comment section. It's my understanding that his mother was too young to convey citizenship to him because that was the law at the time, and because his father was from Kenya, he wasn't a citizen, and that's what kind of that birther thing came from. And a lot of the old people will tell you that women didn't have rights. Remember, women didn't have rights at that time period. They couldn't even convey citizenship to their kids. It was wild. It was wild. You got to look at the law and look at the history of where we came from and where we are. I mean, women couldn't even have credit cards until like the 1970s. You couldn't even open a bank account unless your brother or your daddy opened it for you. Okay? There was a millionaire, I don't know if she was a multi-millionaire black woman out of California. She a black woman, and I think I talked about her once on this page. She actually had to open all her bank accounts in the name of this white man who was like her accountant or business partner, and in order to hold all their money, because women didn't have a right to open bank accounts at the time. And what ended up happening, he died, and his wife ended up getting all the woman's money, saying that was my money anyway. So, that's why we don't have a lot of history. We couldn't do, it was a bad situation, but we made it through. But anyway, I don't want to get too far off the subject. We got 27 super chats. Correction, my 2 cents revised correction. If a male U.S. citizen gets a foreign student woman pregnant, that child would be a U.S. citizen because of the father being a U.S. citizen if he claims the child. And as far as Social Security, they have workaround for that. It's a I-10 work permit. Yeah, that's exactly right. But the thing you need to understand is, if the child is born in the United States as the law is right now, they're an American citizen. What they're proposing is in the future, if the parent is here illegally, that child is not going to be a U.S. citizen. That's what they're saying, man. It's going to really upset a lot of what we see as normal. TNTZ Claw, thank you for the father. Thank you for what you do. Appreciate you. Also, Secrets, We Weep, 199. Thank you so much. Cultural Superpower, appreciate you. And also for the $4 super sticker. And also C. Perry, thank you so much. We got 27 super chats. That is amazing. Thank you so much. You all are awesome out here. I appreciate everybody for the super. And big shout out to Made by Miko. Now, again, I want to kind of just bring this on home and wrap this thing on up. I don't want to have people here all day. I got a few more things to say, and we're going to ease out of here like some bosses. All right. Now, I guess I should leave you with this. Shout out to everybody who contributed to the super chat, the Cash App, and the PayPal. And shout out to everybody who liked the broadcast and everybody who has taken the time to subscribe to the channel. Please do so. Please subscribe to the channel. Don't have me out here begging. But what we're witnessing right now is it wasn't just an oral argument in the Supreme Court. Okay, this is not just lawyers going back and forth over technical language. This is a direct confrontation at the highest level of our legal system between text reinterpretation, present politics, constitutional permanence, and the president and his authority. But more than anything, this case is about something way deeper. It's about who gets to define what it means to belong in the United States of America. Because remember, you heard what he said, the Indians weren't even citizens. You hear that? Think about it. Come to your country, take over your stuff, and say, you're not even a citizen of the country. That's bold, right? But that's how serious it is. That's how serious citizenship is. And it's not just about, a box you check. It's the foundation of rights. No citizen, no rights. You're a nobody. That time period after Dred Scott, before the 14th Amendment, anything can happen to you. You see, it determines your standing. You can't buy a house. You have no protection. You don't have the protection of the full weight of the Constitution. You're not even a citizen. And see, once we start analyzing that foundation, once you start stretching it, like we've seen happen over the past 100 years, or reshaping it or detaching it from its original purpose, you don't just change one rule. You change everything built on top of it. You affect representation. You affect policy. You affect how rights are distributed and protected. And that's not a small shift in a country that is a country of laws, not men. That is structural. So the question in front of the court is not just what the 14th Amendment says. The real question is whether the Constitution means what it originally meant, or whether it becomes whatever the politics wanted to be at that time. Because if the answer is that, and it could be redefined and expanded and contracted or reinterpreted, interpreted, or based on political policy and the whims of the people at the time, then we no longer are anchored to the Constitution. We are anchored to a direction that is very different than the system that we have now. And what I can guarantee you is this, family. The way the country is headed right now and the demographic changes, whether you love this country, like this country, don't like this country, we're going to need to be anchored in something because things are going to be different. You got a whole generation of young people growing up on Nick Fuentes and Charlie Kirk. And black people, foundational black American people. This is a time we've been through. Our ancestors have. But it's something that we need to prepare for. So understand this clearly. Whatever the court decides here is not just deciding one case. It's setting the boundaries of citizenship itself. And once those boundaries move, they don't easily move back. And that's why this matters. That's why people are paying attention. That's why, this decision is going to shape this country far beyond this particular moment. That's why I took the time, because I thought it was important. And I wanted to make sure my audience recognized how important it was. And that's why I took the time to do this today. But either way, thank you all so much. I appreciate you guys. I love you. As I always say at this time, this is Uncle D, and I'm out.
In the Spurling podcast, hit the like button, subscribe.